Yes.
I'm saying for listing a matter for admission.
Okay. Give it to the court martial.
May I please, Your Lordship? Lordship, I beg to mention for a withdrawal. It was filed inadvertently. My senior Mr. H. Puraguhai had come before Your Lordship yesterday. So now.
Or withdrawal.
Yes.
When do you want?
Tomorrow.
Maybe, Your Lordship. Lordship, item number 62 of supplementary list. This is tagged along with an analogous from 52 onwards. This matter came up on 12/6, and Your Lordship was pleased to give us 3 weeks, give the respondent 3 weeks time to file affidavit. This is wrongly tagged with the other analogous matter. 62. The records, the order may be perused. It's wrongly tagged. 60.
Okay, we'll keep in mind. Mr. R.J. Das. We'll keep in mind when we examine that patch.
Item number 62 method. We have considered the other side, Lordship. Matter can be adjourned for today, Lordship.
No. There is. Withdraw.
Day after tomorrow, Lordship.
Let us examine. There is an administrative order of the Chief Justice. Let me find out.
Lordship, with the consent of respondent, I beg to mention item number 39 and 40, Lordship.
13.
39 and 40, Lordship.
39 and 3940.
Yes, Lordship.
No, I am affidavit for the respondent, my lord. I file my affidavit.
I have received the affidavit, Lordship, today, Lordship. So I may pay some time to file affidavit in reply in both the cases, Lordship.
Okay, Mr. P.
Sharma.
Okay. Mr. P. Sharma, learned counsel for the petitioner in both the cases, has sought for and is granted how much time? 3 weeks time to file reply affidavits in both the cases. Mr. S. Bora, learned standing counsel, GMC, for the respondent authorities is present. List the cases
Lordship, first week of August, Lordship.
on first week of August.
5th August. Item number 40, there is interim, Lordship.
Yes,
The
my
interim order
It petition the agent.
passed in WPC number, so and so. Shall continue till the next list.
0508.
Please, Your Worship. I wish to mention item number 12, 13, and 14, my lord.
12, 13 and 14.
I, on behalf of the AK4 customer, my lord, feel unable to appear today, my lord. The matter will pass off.
Okay, on the prayer, Mr.
Yeah, Ahmed.
N. Ahmed, learned counsel for the petitioner. When do you want? Friday? Release the case on Friday. Same.
Wait, please, Your Lordship.
Mr. Please revenue, aforesaid, revenue, and SS Roy are present.
May please, Your Lordship.
Same order 12, 13, 14.
1906.
May please, Your Lordship. I beg to mention item number 28, Your Lordship.
20.
Yes, so 28, Your Lordship. Your Lordship, in this case, we have not been filing affidavit, so kindly allow some time to file an affidavit. And we have taken consent from the other party as well.
You are for?
For BN Gogoi, Lordship. On behalf of BN Gogoi, respondent.
How much time you need?
After vacation, Lordship.
Okay. Mr.
T Taku on behalf of BN Gogoi.
Standing counsel GST has sought for and is granted 3 weeks time to file the counter affidavit on behalf of the respondent GST authorities. It is submitted that consent has been taken from the learned counsel for the petitioner to make the prayer. Release the case on so and so. Any interim order?
Yes, my lord.
Okay. Mr. AK Sahab present koi dibo. Twitter present koi dibo. The interim order past shall continue till the next date of this.
2407.
May I please, Lordship? Lordship, I beg to mention item number 37, Lordship. Here in this matter, we have filed an IA, Lordship, for strike of the private respondent. That may be come up with this IA, Lordship.
Okay, Mr. M.M. Zaman, learned counsel for the petitioner applicant has submitted that an interlocutory application seeking deletion of opposite party
Private respondent.
has been filed few of the opposite parties. Deletion of names of few of the opposite parties has been filed and the same is not listed today. He has sought for listing of the case along with the said IA after a week.
I have filing number is there.
I'll list the case accordingly after a week. On a date to fix by the office.
Lordship, vacation, Lordship, if possible, next week, Lordship.
I have said 1 week.
Lordship.
Yeah, may I please, Lordship? Lordship, item number 6, can it be taken up at 2, Lordship, because I,
Oh, no, we don't take 2.
Lordship,
After motion matters, we'll again call up.
issue is that, Lordship, I have taken wrong brief. So I have brought a wrong brief. I'll have to again visit my office to collect the brief. That is why I'm submitting. It may be taken at 2, Lordship.
After the motion matters,
I'll have to travel to the supermarket.
okay, otherwise you will accommodate.
Lordship, may I please, your Lordship? Lordship, with the consent of the other side, Lordship, I beg to mention item number 21. May it kindly be fixed after vacation.
Yes, who is the respondent?
Hearing for the respondent, Lordship.
You are for GST.
Lordship.
Have you filed any counter?
No, Lordship.
Okay, Mr.
J. Chopra.
J. Chopra, Learned Counsel for the petitioner has sought listing of the case. After 3 weeks, Ms.
R. Hussain, Lordship.
R. Hussain, Learned Counsel on behalf of
Mr. S.C.K.L. Mr. S.C.K.L.
Mr. S.C. Kyle and a senior counsel and special counsel GST is present. Post of as no counter affidavit has been filed by the respondent GST authorities, command the same be filed within 3 weeks' time. Release the case on so and so.
Interim.
Interim order. If any shall continue till the next.
2407.
Please, your Lordship. Lordship, with regards to item number 41, we have circulated an adjournment slip, Lordship, with consent from the other side. Item number 41, Lordship, of daily list.
These are for service report. We'll see.
Much obliged.
May it please the Lordship. Lordship, I beg to mention item number 18 and 19, Lordship. It's a tag
Okay.
matter, Lordship.
Mention memo.
Yes, Lordship. Matter
You are for petitioner.
I'm for the respondent Gail, Lordship. Respondent number 1 and 2, Lordship. For the
P. Nirola
M. Nirola.
and P. Nirola. Learned Counsel on behalf of respondent GAIL authorities has sought for an adjournment with the consent of the Learned Counsel for the petitioner and other respondents. Post of a mention memo to that effect has also been circulated yesterday. Post of as sought for. List the case. After,
Lordship, on 4th of August, Lordship.
list the cases on video.
Fourth-
Normally,
5th.
normally,
5th August.
I don't allow on a hearing day unless I see the brief.
Yes, obliged.
May it please your lordship, I beg to mention for listing of one WPC, my lord, for motion. So kindly, lordship,
When? Friday.
day after tomorrow,
What
lord.
is the subject matter?
Lordship, this is a land acquisition matter, my lord.
Friday.
Obliged.
Lordship, I beg to mention item number 44. We have been newly engaged advocate for respondent number 2 to 5. 44. We have been newly
Okay,
engaged.
we'll see. This is service report only. You'll be there.
May I please your lordship, I beg to mention for listing, lordship, for orders. Orders, lordship, listing.
Okay, give it to the court master.
May I please, your Lordship, I beg to mention item number 7, Lordship. Kindly pass over for the day. I am appearing on behalf of N.J. Datta, Lordship.
Okay, on the prayer of Mr.
I Islam, Lordship.
I Islam Learned Counsel preparing for the petition. The case is passed forward.
Next
Okay.
week, Lordship.
Aforesaid, Revenue, SS Roy, present.
Lordship, beg to mention for listing the matter for orders, Lordship. Matter related to custody of elephant. Right if possible, Lordship.
What is the subject matter?
Listing the matter for orders.
Huh? No, what is the subject matter of the petition?
Custody of the vehicle, custody of the elephant.
Custody of the elephant. Next week,
May I please, your Lordship? My lord, item number 27 may be adjourned today.
27.
Yes, ma'am.
Okay, on
I am
the
the
prayer,
respondent. With the
you are for
respondent. private
respondent,
respondent.
S.A. Ahmed. You have informed the other side?
Yes, ma'am. Yes.
Learned Counsel for the respondent number 6. Release the case after 3 weeks. It is submitted that consent has been taken from the land council for the petitioner to make the claim.
May I please, your lordship? Lordship, praying for listing of filing number 7003 of 2026, my lord. My lord, it's a file on
What?
15/6. My lord,
What kind of pleading case?
my lord, this is the eviction matter, my lord.
No, what can read petition?
Yes, my lord.
Read petition.
Yes, my lord.
You have filed it.
Yes, my lord.
Filed it.
Oh, my.
Daily list for motion. Item 1.
Lordship, in this case, this honorable court by order date 2/5/25, they directed the contemner to consider the case of the petitioners for settlement of land.
Heard Mr. J.
J.
Das, learned counsel for the petitioner. This contempt petition is filed alleging non-compliance of the direction made in an order dated 2/5/2025, passed in a writ petition WPC number 481/2024. Post of by the order dated 2/5/2025, the respondent was directed to consider the case of the petitioners for settlement of a parcel of land, described therein, in accordance with the applicable acts and rules within a period of 4 months. Post of it is ever done. The order dated 2/5/2025 was duly brought to the notice of the respondent. Post of issue notice returnable in 4 weeks. Steps upon the respondent by speed post to improve working this counter.
Value of
Item 2. Item number 2.
This is for deportation. The other council has to, the last time it was instruction for the opposite party to bring instructions.
CGSC to bring.
B. Sharma,
Yes,
Ms. B. Sharma.
she was here, Lord.
So Lordship, there is a guideline of 24th April 2014. And as per that, Lordship, before that expiry of that period, she has to apply before the authorities. If there is, she has documents. If not, then also she has to, that this is the stating the position, Lordship. That much instruction till now I have, Lordship. She has to go either it by the state authorities or this by a FRRO to state what is the position and she
We
wants
don't know
to.
the procedure. Please apprise us
Lordship,
about the
in fact, Lordship, I just.
she has served the sentence.
Yes, Lordship. Oh, may take up after Sunday because I have got it in WhatsApp and I'm getting the printouts, Lordship.
Just the reason bench otherwise has passed in a similar matter, has passed from Kaya 6.
And then what happened? Did we go ahead?
Why it was before division bench? It was a writ petition. Why it was before division bench? Which court has roster? Single bench or division bench?
That was because the division bench was taking foreigners matter. So in
Ah.
that case, eventually.
Madam? If this court does not have the roster,
No, your lordship, in that
because this is an order passed in a similarly situated
similar.
Yes.
person, some roster কি আছে? Foreigners কোনো some.
একটু মানে খেলা বাংলাদেশি নহয় যে কমজিন বাংলাদেশি নহয় অকমান বেলেগ একচুৱেলি
নহয় নহয় এই যে উইকলি যে আহে হা
ইয়াত পৰত আহি ধৰে
writ petition foreigner matters. Division means two otherwise.
Because we tried mentioning there, but because since it's only about deportation, we were advised to get it listed before the single.
No. Who advised you? Registry advised you.
Bench.
We don't know, but madam,
Lordship,
whether this, you take a call
Lordship.
on the judgment also. In the meantime, I'll ask the registry also whether this is to be listed Friday or Monday. Let her take a call. If this judgment is okay with them, then we'll pass the similar order. In the meantime, they will ascertain whether this is
So there is another order on 3525, the last, it's not the last final order in this case.
Is it not?
Yes, Lordship, list the matter on 3525.
Eventually, what happened in this case?
35. What is the final order?
Final order. Eventually, what happened in this case was the SP Karimganj. They sent a constable at the detention. They took him and sent it to the embassy, Nigerian embassy. In this case, also we Nigerian.
Now, what is the final order? Let us see.
Final order.
Place the final order. Let her. Heart. Mr. Deportation. Before division bench. Huh? Division bench. Okay. Might be before division bench. As per notification. Heard Mr. D.K. Agarwal, Learned Counsel for the petitioner. And Ms. B. Sharma, Learned Settlement Counsel for the respondent number 1 and 2. And Mr. N. Goswami, Learned Junior Government Advocate Assam for the respondent number 3 and 4. Para. Ms. Sharma has submitted that she has not yet received complete instruction in the matter. Gusto Mr. Agarwal has placed a copy of an order dated 9/5/2025 passed by a division bench in WBC number 2207/2025. Whereby in case of a similarly situated Nigerian citizen, a copy of the notification number 91 dated 14/11/2025 is also placed before the court. Postal. Having regard to the submission made by Mr. Learned by the Learned Counsel for the parties and a notification dated 91/2025, 91, the matter raised to examine whether this matter is to be placed before the single bench or the division bench number 2, and thereafter to list the case accordingly before the appropriate bench. In the meantime, Ms. Sharma shall complete her instruction. Monday.
Monday.
Monday, 2206. Item number 3.
May I please, my lord, Mr. B. Chaudhary is appearing in this matter. He is right now on legs in code number 10, my lord. What was my lord?
Sometime?
Item 4.
Award is already there.
Let's take some time, but one.
More delay will result in cost, imposition of cost. If already award is there in 2023, if it is not released,
I'm told that some other person has also claimed that
if it is claimed, it is to be forwarded.
some shopkeepers are there, Lordship. Some
Whatever, it was under which act?
Some shopkeepers are there.
It was under which act? Award is under which act? National Highway Act or 2013 Act? National Highway Act. You should have forwarded the matter if there is dispute. Heard. Mr. Will issue notice then. Learned counsel for the petitioner. Petitioners. Ms. Arbora. Who is for 1 and 2?
One, I can appeal. One.
Okay, learned standing counsel NHIDCL for the respondent number 1 and 3. 1, 2, 3. Aforesaid, revenue 4 and 8. Full education. Mr. T. Thakuria, standing counsel. Education Department for the respondent number 5, 6, and 7. And Mr. N. Gusam.
9, 10, and 11.
Learned junior government advocate for the respondent number 9,
10,
10, and 11. Full stop. Para. Agreed by non-release stroke disbursement of an awarded amount of compensation, comma, rupees 53 lakh 36,422 against acquisition of land of the petitioner school for 4-laning of National Highway 17 within bracket package number 8 under the National Highway Act, comma, the petitioners have preferred the instant petition. Full stop. Para. On the previous date of listing, comma, the government advocate, junior government advocate, Assam, was asked to obtain instruction. Full stop. Today, Mr. Goswami, on the basis of an office letter dated 15/6/2026 received from the respondent number 10, has sought for some more time. Face the instructions. Issue notice returnable on so and so. As so and so appear accepted. Formal notice, no formal notice. Extra copies within 2 working days. The respondent number 10 shall ensure that its response is filed before the returnable date, as the petitioners have projected that the possession of the acquired land had already been taken in the year 2023 after assessment of the compensation amount under Section 3Z within bracket 1 of the National Highway Act 1956. Right?
That's tied to 22nd July. Item number 5.
What is the disputed amount?
3,97,587, my lord.
What was your balance?
Balance, my lord, 11 lakh something, my lord.
Okay.
It is there, my lord.
Heard, Mr. R. Amin,
Yes, my lord.
learned counsel for the petitioner. Well, nodal officer. Yes, Mr. Roy. What is that? You file an amended cost title so that we can interact with all these authorities. They will not come, right? All these 3, 4, 5, they will not come here.
Yes, my lord.
But for facilitating immediate response.
Nodal officer cyber. This.
Give the Mr. So-and-so, Aramil and counsel for the petition is permitted as sought for 2 days time to file an amended cost title for impleading. What is the name? Give it to the court master. For impleading so-and-so as party respondent number 6 in the instant litigation. Lays the case on Monday. File it today.
2206. Item 8.
Registration liability cancel. Yes, madam.
Lordship, this matter is pertaining to GST calculation, Lordship. And this is covered by your.
Yes, madam.
Yes, your Lordship, it's a covered matter.
Okay, we'll close this. Hard miss.
B Sharma, Lordship.
B Sharma petitioner. Who is for whom?
Respondent number 1, Vikas Sharma.
Mr.
Vikas Sharma.
B Sharma, Central Government Counsel for the respondent 1 is
Lordship, I'm appearing for respondent 2 and 3. P. Upadhyay on behalf of Mr. S.C. Alia, Lordship.
okay. 2 and 3. Disposal.
Obliged.
Item number 9.
Eviction already done. What relief?
Eviction done on October.
That
Hmm?
come for your Lordship. No about
Government wasteland to landless citizen.
Similarly, situated persons have already approached this honorable court, your Lordship.
Heard, Mr.
ML Chaliya.
For the petitioners and Goswami. Oh, JND. Junior Government Advocate.
1, 4, 5, and 10.
1, 4,
5 and 10.
5 and 10. Any CGC? CGC, SSR, CGC, 2, and border, revenue 3. Forest, M. Kolita, Learned Standing Council, Forest, 6, 11. Health and Family, S. Sharma, Health and Family Welfare, 7 and 8. Education, B. Deca, Standing Council, Education. 10. Public health. Oh, you were there. Oh, this is different department. Standing Council, Forest Department, and Public Health Engineering Department. And 12, something else. Notice.
Yes, Your Lordship. Lordship, in regard, they have annexed the order of Gwalpara district, Your Lordship. But then
And they are what? They are evicted from what?
from Nagaon.
Nagaon.
District also, their same petitioner council, they had earlier set of cases, Your Lordship, when notice was issued, Your Lordship. They have not annexed those orders. They have annexed Gwalpara.
Oh, from forest areas.
Yes, same area, Your Lordship. Lutumari area under Kamrup Revenue Service.
Land Council for the party.
Same area,
Indicated that in similarly situated persons have already approached this court by writ petitions, and notices have been issued in those writ petitions. Issue notice returnable in 4 weeks. As so as extra copies within 2 working days.
Item 10.
10 to 7.
Any same or what?
Yes, Your
Parties are same. Or the petitioners are persons who were evicted from areas within.
Gwalpara district, Hasila bill.
Oh, no, earlier one.
Earlier one was of Nagaon.
Lutumai Reserve Forest.
Lutumari.
Lutumai or Mari.
Lutumari. It is written Lutumari, Your Lordship.
No, in the notice.
No.
Lutumai.
Lutumai.
Who were evicted from Lutumai Reserve Forest areas. Next one is
Gwalpara district.
Lutumai is in which district?
It is from Nagaon, Your Lordship.
District Nagaon. Next, parties are same. Serial numbers are same. Respondents different. Different. Okay. Mr. Roy, you are for SS Roy. Please repeat. 1, 3, 4, 5.
I'm
And Bordoloi.
2, Your Lordship.
Revenue 2. S. Sharma, Health and Family Welfare, 6 and 7. B. Deka, Education, 8. Miss M. Kolita, PHE, 10. 11, notice, speed post, 2 working days. The petitioners are persons who were evicted from. Where is the notice? Evicted from what area?
Wetland level.
Huh?
Hasila bill, Your Lordship.
Hasila Bill.
Hasila bill.
Hasila Bill. A wetland area.
Notice is on page 44, the translated copy, Your Lordship.
Hasila Bill,
Hasila
wetland.
bill.
I can see. Extra copies within 2 working days.
Item 11.
Oblige, Your Lordship.
May I please, Your Lordship?
Hmm.
Is possession an ancestral plot of
Yes,
land.
Mr. Why mutation application not processed? Get the instruction.
Lordship.
If it is in a process, we'll direct the.
Lordship.
Okay. Heard Mr. P.K. Gogoi, learned counsel for the petitioner. Mr. A. Aforesaid, Revenue, 1.
2, 3, and
SS
4.
Roy, 2 and 3. 2 and 3.
Lordship.
Because the petitioner has stated that an application filed for mutation in respect of a plot of land has not been processed filed by the petitioner on 5/2/2026 has not been given consideration by the respondent authorities, more particularly, the respondent number 3, till date. Mr. Roy, Learned Junior Government Advocate, is to obtain instruction as regards the present status of the application and to place the instruction on the next date. Place the instruction after we release the case on next week. Same day, Wednesday.
2406.
You need any?
One extra copy.
Mr. Gogoi and counsel for the petitioner shall furnish a copy of the writ petition along with an extra to Mr. Roy during the course of the day to enable him to take necessary steps from his end.
24th June. Supplementary list, item 49.
Made before your lordship.
Yes.
My lord, I have gone through the 3 cases that your lordship referred. I hope those are the 3 cases.
Tam Chakma.
Yeah, my lord, I have got, I'll just give your lordship the name. The extra copy is there with my junior. Malabar Hussain, that was disposed of on 24/1/2025. Here, second appellate authority gave direction to SPIO to furnish the document. The document was not furnished. Your lordship directed the petitioner, gave liberty to approach the second appellate authority under section 18(1) of the RTI Act.
Oh no, these are not the cases. It is Sona Dhan Sakma.
Yes, Lordship. 5132 of 2024.
I intended about that.
I see. I have 3. One is Islamuddin Barbhuya, the second one, and the other is Nandita Gwala.
Do you have a copy?
I do not have a copy.
this is the
I
copy.
can give a copy to
Mr. Prasad, you can see.
5132.
I have no objection.
All right.
My lord, so far as asking us to go back to the second appellate authority, I have only one submissions to make, my lord, that I made yesterday. That if your lordship can kindly come to page 79 of my writ petition. The order starts from 73. The last part is at page 79. And the last paragraph that I will read is, in view of the fact that a case in this regard is already under review at the Lokayukt Assam, and the observation made above, the Commission appears to have no reasons to issue specific directive in the instant case and request the first appellate authority of Fire and Emergency Service Assam headquarters to take appropriate action on the basis of the facts and observations mentioned above. The facts and observations that are mentioned are relatable to Jharkhand case, my lord, which was upheld by the Honorable Supreme Court. And therefore, yesterday, my lord was of the view that this will constitute a direction.
Yes.
First appellate authority. My lord, if your lordship clarifies that, we are ready to go and file.
Yes, Mr. What do you say about page 78 and 79?
79, Lordship, my learned senior has read that the direction to the first appellate authority which was not complied with, that is the allegation. So once the first appellate authority does not comply with the direction of the second appellate authority, under 19.3 it will be second appeal because it's appellate authority which has not done what is it will amount to remand of the matter, Lordship. The direction would amount.
It was a second appeal.
Which was direction was given to first appellate authority would be
second appeal. It was by the Assam Information Commission, right? And there regarding some documents submitted by rival bidder,
Lordship, with regard to
in a tender process.
Yes.
Then the second appellate authority, that is the Information Commission,
disposed of
referred to a judgment of the Jharkhand High Court, wherein last part, if the authorities of government refuse to disclose the document, the very purpose of the act will be frustrated.
Yes, Lord.
Moreover, disclosure of information sought for by the petitioner cannot and shall not be a trade secret or commercial confidence. Rather, disclosure of such information shall be in public interest, inasmuch as it will show the transparency in the activities of the government. Then whatever Lokayukta, it is a different issue.
Now, the first appellate authority was directed to provide the information, do the needful.
Appears to have no reason to issue specific directive in the instant case. Request the so and so. to take appropriate action on the basis of the facts and observations made above.
Lordship, by the order, it appears that it will be remand in effect. It will be remand to matter to the first appellate authority because direction is given, no specific direction was given and referred the matter to the first appellate authority, Lordship. So if the first appellate authority did not do what is supposed to be done by the act, then they are aggrieved by that order or not passing of the order. They will come back for the second appeal, Lordship.
No, first appellate authority is not acting.
Absolutely, Lordship. So now, if on the direction of the second appellate authority, if the first appellate authority refuses or does not pass an order, they're aggrieved by that inaction on the part of the first appellate authority. So eventually, if there is aggrieved by the order or non-passing of an order of first appellate authority, they ought to come for the second appeal. However, in this case, the second appeal is already disposed.
Why you are making such submission?
Then
It is non-compliance. It is non-compliance simply.
But Lordship, non-compliance against the first appellate-
Request does not mean he has used a soft word, does not mean that it is not a command.
Absolutely, Lordship, that would be another, but
Just because he has used a soft word,
Lordship,
doesn't mean it is not a command.
they can come back on a non-compliance, then that can be considered.
It should not come back as a
Appeal.
second appeal again.
Lordship, that would also be, I'll agree to.
Yes, some.
My lord, your lordship will kindly see 19.7 for a second, section 19.7 of the 19.7 for a second, my lord. The decision of the Central Information Commission or the State Commission, as the case may be, shall be binding.
Yes.
Therefore, he should have taken action, my lord. We had given reminders. He's not doing anything. So we will file, but if you if your lordship can make that observation which your lordship said.
This 19 has been dealt to it.
Yes.
That binding nature of direction has been dealt to it in this Sonadhan Sakma. That is 5132/2024. And there we say that this body is not teethless body.
My lord. Section 18 and 20, read with 20, gives the my lord statutory authority over the subordinate authorities.
Yes, yes. Section 18.
Yes. That will be, complaint will be filed.
And the power of the Information Commission in section 30, 31, 32, those are dealt with. Now it is functioning or not functioning?
Yes, Lordship, it is
functioning.
The two commissioners were.
Two commissioners are there.
Yes, Lord.
Okay. Had it not been functioning, we could have. You exhausted the remedy of before the SPIO.
Yes, madam.
First appellate authority, second appellate authority.
Yes, yes.
Okay, heard Mr. D.K. Mistral and Senior Counsel to the virtual mode along with Mr. B. Prasad, Learned Counsel for the petitioner. Mr. S.S. Roy, Learned Junior Government Advocate, Assam. For the respondent number 1, P. and 4, and Mr. D. Deka, Learned Standing Counsel, Assam Information Commission for the respondent number 2. Full stop. Para. The case of the petitioner is that he filed an application before the SPIO means S stands for
State Public.
State Public Information Officer within bracket SPIO, Fire and Emergency Services on 15/10/2024 seeking information as regards certain clauses in a incorporated in a tender document in relation to a tender process initiated for awarding contract for supply of fire proximity suits. First off, the SPIO, by his letter dated 21/11/2024, refused to provide those information, allegedly on the ground that such information were exempted under Section 81D and Section 81J of the Right to Information Act 2005, RTA Act for short. Besides, first off, the SPO further mentioned that the information sought for by the petitioner were classified and confidential to a third party. The SPO even refused to provide the minutes of the technical and financial evaluation on the ground that they were under consideration of a judicial body. Post. Aggrieved thereby, the petitioner filed a first appeal under Section 19(1)?
Yes, Lord.
19(1) of the RTA Act before the First Appellate Authority against the decision of the SPIO, against the decision of refusal to provide information by the SPIO Fire and Emergency Services Assam. The First Appellate Authority, by an order dated
29/11.
22/01/2025, upheld the order of the SPIO dated 21/11/2024 and dismissed the appeal. Full stop. The petitioner had thereafter preferred a second appeal before the Assam Information Commission on 10, second appeal under Section 19(3).
Yes, Lord.
Of the RTI Act before the Assam Information Commission on 10/4/2025 against the order of the SPIO and the orders of the SPIO and the First Appellate Authority. First up, para. The second appeal came up for consideration before the second Appellate Authority on 21/5/2025. And took into notice that a case was registered in the office of the Lokayukta Assam. Case number 5/2023. by referring to a judgment of the High Court of Jharkhand in the state of Jharkhand versus Naveen Kumar Sinha, AIR 2008, ZHAR 19, decided on 8/8/2007, the second appellate authority took into consideration observations made by the High Court of Jharkhand in the case of so-and-so to the effect that if the authorities of government refuse to disclose the document, the very purpose of the RTI Act would be frustrated. Full stop. And disclosure of information sought for by an applicant under the RTI Act, cannot and shall not be a trade secret or commercial confidence. First of the High Court has proceeded to observe that disclosure of such information shall be in public interest, inasmuch as it would show the transparency in the activities of the government. First of, taking note of such observations, the second appellate authority had called upon the first appellate authority, that is the
Respondent number 3, my lord, here.
Respondent number 3, to take appropriate action on the basis of the facts and observations made in the order dated 21/5/2025. Post of para.
My lord, if your lordship just permit me, this order was upheld, my lord, in SLP. The SLP was dismissed on the basis because of the facts and circumstances of the case. I have placed, my lord, yesterday the SLP.
Mr. Mitchell and its senior counsel appearing for the petition has submitted that against the said decision of the Jharkhand High Court, the state of Jharkhand preferred a special leave to appeal, SLPC number 18030/2007, and the Honorable Supreme Court on 5/10/2007, taking into consideration the facts and circumstances of the case, was not inclined to interfere with the judgment of the Jharkhand High Court and dismissed the SLP. Para. It is the case of the petitioner that after the order dated 21/5/2025 passed by the second appellate authority, the order was brought to the notice of the first appellate authority on 18/6/2025 with a reminder on, followed by a reminder on 24/10/2025. Despite such efforts from the petitioner, the first appellate authority is not found to have acted in terms of the order dated 21/5/2025 passed by the second appellate authority. It is the case of the petitioner is that the first appellate authority appears to have been sitting in appeal over the order dated 21/5/2025 passed by the second appellate authority. Mr. Dekal, Learned Standing Council, Assam Information Commission has submitted that the petitioner, without approaching the Assam Information Commission first, has approached this court by the instant writ petition. First of para 6. Para 6. This court in a judgment and order dated 12/11/2024 passed in WPC number 5132, 2024. Sri Sonadhan Sakma versus so-and-so has entirely observed that the State Information Commission on receipt of a complaint, has the power to exercise its jurisdiction under Section 18 of the RTI Act by taking cognizance of the complaint received from a person who fulfills the expression any person occurring therein and who has already exhausted the remedies under Section 9, Section 19(1) and Section 19(3) of the RTI Act on its own merits by initiating an inquiry as contemplated under Section 18. If the contents of the complaint falls within any of the ingredients of subsection 1 of Section 18 of the RTI Act, on reaching a satisfaction that there is a reason to inquire into the matter, it has been further observed that the Commission is vested with the powers delineated in subsection 3 and subsection 4 of Section 18 of the RTI Act to deal with such a complaint. 7. Yatakali order report 21/5/2025. We have directed the Commission to take cognizance on your complaint
My lord.
so that it can issue warrant also.
All right.
Mr. Prasad, you get hold of this. 5132/2020.
Decision will be taken within a time frame, my lord.
Yes, Mr.
Will give us.
You file a complaint. File a complaint, Mr. Deka would be there.
No,
File a complaint as early as possible.
Yes, Lordship. Oblige, Lordship.
Item 50.
Hey, please, your Lordship. Lordship, they respond.
Yes.
Please, your Lordship, the respondent number 2 has issued the requisition order, your Lordship, under the 1964 Land Acquisition and Requisition Act, your Lordship, and subsequently has also issued a order seeking to take possession of my land, your Lordship. I have my land, the petitioners are having a Mayadi Patta land, your Lordship. The Lordship, the respondent number 2, under a requisition order, has started construction of a drainage system, drainage project, without a notification under Section 6, your Lordship, of the 1964 Act, your Lordship, which cannot be done in my respectful submission, your Lordship. Because under Section 6 for acquisition, notification has to be issued, and subsequently claims for compensation under Section 7 has to be called for, your Lordship, before carrying out such construction. So under a requisition order, construction cannot be carried out, your Lordship. This is my humble submission, your Lordship.
No, which provision you are referring to?
I'm referring to Lordship section. The requisition order has been issued under Section 3 of the 1964 Act, your Lordship. I've annexed the Act for your Lordship convenience. It starts from 105, your Lordship, page number 105. So even under one more submission is that while issuing the order of requisition also, no notice was made to the petitioners, your Lordship, as mandated under the Act, your Lordship.
Yes. Section 3 compliance. Where is that? Section 3 compliance.
Also Section 3 and Section 4 also, your Lordship, because under Section 4 also, for taking possession, notice has to be given to the landowner, your Lordship. Otherwise,
Section 4 is there at page 135.
yes, 135.
First, Section 3, that intention to acquire should be there. Where is that order?
That order is not reflected.
You try to mix up Form B. You try to mix up Section 3 and Section 4 together. That is not. First, see Section 3. If in the opinion of the state government or any person authorized, there is delegated authority, maybe deputy commissioner. Section 3, page 106.
Yes, madam. If in the opinion of the state government or any person authorized in this behalf by the state government, it is necessary so to do for maintaining supplies and.
So any authority, let us assume deputy commissioner,
Yes.
he has been delegated with the power.
Yeah. So and so shall.
For what purpose it was? Construction of drainage system. Okay. Could
May
be.
by order in writing requisition any land.
Formed of so and so for the very video so and so the case. May by order.
May by order in writing requisition any land or may make such further orders as it appear to it or to him to be necessary or expedient in connection with the requisition.
So in the opinion, that should be there.
There should be there.
Then come to, there are two provisos. Then page 107. An order under subsection 1.
Mr. Babujai has come.
Place the order under section 3(1). Yes. If it is the valid limit, valid limit. But if the foundation falls, structure falls.
Absolutely. Acquisition.
3(1).
Yes.
When will? Tomorrow.
Can it be on Monday, my lord?
Friday. Everything is there. If it is there, see the form. Where is the form? Form A.
That clerkship will find at page.
Form A. 1 to 3. Page 1 to 3.
Yes, my lord.
Where is that order? Place this order.
Yes.
If the everything has started off well, it's okay.
Because already started and my lord.
No, still,
Yes.
everything can be invalidated. Right.
Otherwise, if lordship may be pleased to direct to produce the records, you can produce the records, madam.
It is up to you.
Yes.
It is up to you. I'll go by your order placed. And if you're welcome to produce a record. Order under 3(1). This, if you have, see page 1 to 3.
Yes.
You must have misled by the first paragraph. Read it.
Yes.
Now come to page 107. This form, you will come to page 115.
Yes.
Rule 3.
Yes, rule 3.
When it is necessary to so and so, an order of requisition, 116.
Yes.
Under section 3(1) shall be in form B.
Shall be in form B as far as may be with such modification, if any as may be necessary. Now this modification, my lord, pertains to the purpose and object for requisition. Because
But section 3(1) says, there must be an order.
So there has to be an order
By order in writing.
order in writing, that is the condition precedent.
Huh. That is the condition precedent that you have formed an opinion.
Yes. Yes.
That order should be there. Thereafter section 4, thereafter section 6, thereafter section 7. Produce that. We have
Otherwise,
done the work properly. Why should we interfere?
absolutely, absolutely.
But not done, then there is a different issue. We don't say that you don't have power. You have power. But what is prescribed in your statute, that mode is to be followed. Because he has, because he says Form B has been issued straight away.
Form B has been issued straight away, and the word used is displaced persons. Therefore, the rule gives a leeway to the authority with such modification.
Proviso 2A section cannot override the main provision. And just because there is displaced person, that will not permit you not to pass an order under order 3.1.
Because the authority will have to clearly spell out the intention for acquisition. That's it, man. At the
That's
end
it.
of the day, it is that.
There has to be an order under 3.1 before 4.1. Let us see.
Will be testing the action of the respondents vis-a-vis, my lord, the order passed.
That's all. Otherwise, maybe it is a public drainage system for the public.
Their lordship has also passed orders, my lord.
So that is not there, but
proceedings, these are under the.
when a mode is prescribed to do a thing in a particular manner, it must be done in a particular
yes.
manner. That's all. Otherwise, you will get your compensation under the RFCT, LA Act.
Yes.
We'll look into that. But once, where is that section 6 again?
That lordship will find it page 108.
108.
Yes.
May use or deal with it in such manner. And this act has received presidential assent. It is different from.
But my only anxiety, your lordship, is that before disposing me or before disposing me or before carrying
Our
out the
question
construction-
is, how much areas from each of the persons have you done the survey? Please us the information that you have done this survey, that Mr. So-and-so's this much of area is to be.
I will produce the records. The records will reveal.
No, you don't produce the record, you get the records, extract the information from the records and place it.
Absolutely.
Don't permit the court to go through and find out.
No,
You place the chart.
My intention is not to bulldoze, my lord.
No, don't. You say, I will obtain the record, extract the information as regards the petitioner and place it before the court.
My lord.
Right?
Yes. Yes, my lord.
Heard, Mr.
K.
Edeka, Land Council for the petitioner. Mr. R. Borpuzari, Revenue and Disaster Management Department for Restaurant number 1, and Mr. S.S. Roy, Lanet 20. Who is this Restaurant number 4? Mr. R.M. Das, Lanet Standing Council. Which department? Water Resources Department. For the Restaurant number 4. Mr. Borpuzari has sought time till Friday to obtain the order passed by the requisitioning authority under section 3.1 of the Assam Acquisition and Requisition Act, Assam Land within bracket Requisition and Acquisition Act 1964, and the parcels of land to be acquired from the petitioners and the areas of land to be requisitioned areas of land, requisition from each of the petitioners for the purpose indicated in the order dated, order passed under section 4.1. List the case on.
Lordship,
Right.
some protection will be granted to the petitioner because. person-
No, this is a land, this is a public project, public project would prevail over private interest. Let us see. If something is gone illegal, we'll interfere. And the notices were, I am also aware, notices were issued in March. We are in June, Monday.
I will secure it, my lord.
2206.
You need a copy?
Yes. I will download it, my lord.
No, read petition, read petition.
Yes, read petition.
Mr. Decker, Director of the Petition, shall furnish a copy of the read petition along with annexer to Mr. R. Bopujari during the course of the day.
And so obliged.
Timing method. Item 3.
In this case, the petitioner is challenging the adjudication on the ground that the same has been made on best judgment assessment without there being any power under the act to make the best judgment assessment. As you also aware, under the Income Tax Act, VAT Act, all, the best judgment assessment power has to be there. Without there being any power of best judgment assessment, the best judgment assessment cannot be made. Now, you also will find that sections here will place for also, section 59 to 66 are the powers of the assessment. There is no power of the best judgment assessment. You also
Yes,
and similar matter.
base judgment assessment. Any similar method?
In similar matter, my lord came up for this honorable court.
Then we'll not waste time. If similar order is there, we'll not waste time.
You also just see, lord. Otherwise, I will place.
Base judgment assessment provision is there.
Lordship, if Lordship looks into the definition of assessment, base judgment is provided there. And secondly, Lordship, it's an order in original. The alternative forum is there, appellate authority under section 107.
Well, I will tell you, see what has happened in the case below.
So according to you, provisions of CGST Act does not provide for assessment on base assessment method.
Well, what has happened in this case, I may just keep 2 minutes. You see, the hotel and restaurant, and as you know, is aware, then the the booking is made, estimate plates are given. And the price of the plates depend on the items which are there, Now, what happened, they have said that the prior booking was made for 300 plates, but the actual plates were, the bill were 200. So, and in
The issue is first that if he is not vested with the power
my lord,
to make assessment on base assessment method, that is a question of law. This
jurisdiction,
is a case of jurisdiction, lack of jurisdiction.
Similar
Plates and all counting, we are not going into it.
court of the Madras High Court, and they have
Okay.
the similar.
Well, you should notice your question of
I'm also jurisdiction,
adequate remedy, statutory remedy will be kept open for consideration.
We're not going to the merit, we are only on the jurisdiction. issue.
Yes,
The
that's
power
all.
is there.
And Lordship may kindly look at page 335. Why the base judgment as provided in the definition under the assessment was invoked. What
Right.
page 335. Lordship, 14.6, in spite of notices, the petitioner did not cooperate or not produce any evidence on the materials that was collected.
Still, suppose he did not respond, whether
Lordship, if later on, Lordship, if goes to the order, Lordship, the assessing officer has given detailed reasoning for each and every instances.
we'll examine similar matter, almost already notice has been issued.
The issue is only whether best judgment power is there or not. If the act provides for the power, I will go and appeal.
Then there will be appeal.
My lord,
Heard Dr. A. Saraf, learned counsel, listed by Mr. and P.K. Boda, learned counsel for the petitioner. And Mr. B. Chaudhary, learned standing counsel, Finance and Taxation Department, Government of Assam, for all the respondents. First of the petitioner has an SSC under the Central Goods and Services Tax Act has put to challenge. An order in original dated 10/4/2026 passed purportedly in exercise of powers under Section 74 of the Central Goods and CGST Act. First of the primary ground of challenge, apart from other grounds, is that the assessment officer had proceeded to pass the order in original on the basis of base judgment, whereas the provisions of the CGST Act do not empower the assessment officer to make assessment on the basis of base judgment. First of proceeding should, the petition has assailed that the order in original has suffered from jurisdictional error. Mr. Chaudhary, learned standing counsel so has submitted that against such order in original, an adequate statutory and alternative remedy in the form of an appeal under Section 107 of the CGST Act is available, and therefore, the writ petition is not to be entertained on such ground. First of the matter would require consideration, issue notice, returnable on so and so, as Mr. Chaudhary has appeared accepted. No formal notice, extra copies. Heard the learned counsel for on the interim prayer. First of Mr. It is submitted by the learned counsel for the petitioner, learned senior counsel for the petitioner, that in a similarly situated in connection with a similarly circumstanced writ petitioner in WPC number 1632/2023. The court, the coordinate bench has already passed an interim order. After hearing the learned counsel for the parties and considering the ground on which the instant writ petition is, considering the ground that the assessment officer has, the order in origin has suffered from error of jurisdiction. This court is of opinion that privacy opinion, this court is of the privacy view that interest of justice would be better subserved if a direction or to take coercive action against the petitioner is passed. Accordingly, it is directed that till the returnable date, no coercive action shall be taken against the petitioner pursuant to the impugned order in original dated so and so, 10/4/2026.
I'm okay. 2407.
Item 6.
Got the brief?
Yes.
Yes, what is your case?
It may peruse the page number 12. Periodic part-time.
Just a minute, petition legal and tribal periodic pattern number so and so. Yes, parapage.
Lordship, page 12. The original vernacular is on page 15.
You will issue notice.
That's what.
Heard Mr. Abjad Mojumdar, learned counsel for the petitioner, and Mr. N. Goswami, learned government advocate for all the respondents. Projecting that his eviction from patta, periodic patta land as illegal. Periodic patta land in a periodic patta land, terming his eviction from periodic patta land in exercise of powers under Chapter Roman 10 of the Assam Land and Revenue Regulation 1886, the petitioner has preferred the instant repetition. Issue notice for returnable on switch. Steps, as Mr. Goswami appeared accepted. Steps within 2 working days. Extra.
2707. Order no steps. Item 15.
Mr. S. Hogg, learned counsel for the petitioner, has submitted that he may be permitted to take steps for service of notice upon the respondent number 2 and 3 within 2 working days from today. The prayer is allowed. The petitioner shall take steps for service of notice upon the respondent number 2 and 3.
And 5.
2, 3.
And 5 was. 5 was extra copy was to be started. As per order.
And the respondent number 5 within 2 working days.
Right.
From today, in reference to the order dated 15/5/2026. Raise the case up to 4 weeks.
Okay. Okay.
Item 16.
As far as this note, the steps has been taken for respondent number 2.
Okay. Heard Mr.
NK alone.
NK Alam, learned counsel for the petitioner, Mr. N. Das, learned, SS Roy is there. CGC? CGC? Miss A. Pine. Learned counsel on behalf of Mr. J. Sharma. Miss J. Sharma. What is the full name? Okay, J. Sharma, learned counsel for the respondent number 1. Also, in view of the office note dated 15/6/2026, let the case be placed before the Lower Jima Court to ascertain service of notice upon the respondent number 2. Okay, 3 is there. Who is 3? No. Okay, 2. And to place the same. And place the same. On so and so with the report. Next to go details.
2406. Item number 17.
Yes, what is the issue?
My lord, there is a direction to the government to file a affidavit, lordship, by.
Ms. Chaudhary and Mr. Das,
Yes.
both.
I have filed, lordship.
My lord, I have, with regard to that, before that, my lord, I filed an affidavit, it's a reply. With regard to their affidavit, my lord, it shows, my lord, the very case which has been filed, it's not maintainable. In view of the position, the property which is involved here, my lord, already been relinquished. And with regard to that, a registered relinquished deed has been executed. And that has not been challenged till now.
Lordship, can we see
My lord, before that,
Firstly, why this?
page 21.
You were directed to file the affidavit. Why you were, both of you were directed to file the affidavit?
No, my lord, I have taken the plea with page number 21. For a second.
Question was raised by Mr. Das as regards authority of the writ petition to file the writ petition on the basis of the power of attorney. Enclosed as Annexure A to the writ petition, taking into account that the said power of attorney does not identify the land wherein the petition has been appointed as the power of attorney. By the time so the addition being filed to bring a record, another power of attorney. So for you, another power of attorney.
Lordship.
And for you, what?
My lord, with regard to how the government on what authority has given the land, patta land, to
Paragraph
the
8.
private respondents, my lord. Because if your lordship goes to the page, before that, my lord, page 21 for a time being.
Let me understand then first. What is your case?
Lordship, paragraph 8, your lordship, kindly. The Salsa personnels were allowed to stay in my patta land, lordship. Paragraph 8 of order of.
District magistrate issued an order of
No, lordship, order dated 2/4/26, paragraph 8.
paragraph 8.
Yes, lordship. The lordship is just reading that order. Lordship, they were asked,
Okay.
they were directed to file affidavit to bring on record that what procedures they have taken to evict those sulfur personnels from my.
File the affidavit that we don't want to evict them.
No, my lord. The question is, my lord.
No, it has proceeded from 2020 for 6 years. All the points will be considered when the court has directed you.
No, I have.
Then you have to comply.
No, I have written.
And for 6 years, this petition is pending. Now you say that it should have been raised in the first point of time.
First one, I have raised, my lord. I'm saying the page 21, my lord. That's why I'm saying for time being, my lord.
But you file it.
It says.
Court has directed.
No, I'll file it, my lord. I need some more time, my lord. Why I need? I'll explain it, my lord.
Come up with plea that we don't want to evict.
No, my lord. It's not that case, my lord. Page 21 for time being, my lord.
But all these were available for all of you for 6 years. Now don't raise this point at this intermediate point. When the court has directed you, file an affidavit.
My lord, some time, my lord, because it's a case of 2000, my lord. They are still searching on what procedure, my lord.
Question is, if there is anything available, then after search, it can be found out.
Yes, my lord.
If there is nothing available, nothing could be found.
My lord,
It is very simple.
from my side, everything has been done.
Okay. All right, Ms. R. Chorila, Senior Counsel for the petition, and Mr. N. Daslan, Junior Government Advocate for the State Response. Yes, you are for whom? Mr. H. Daslan, Counsel for the Response number 8. And Mr. T. R. Sharma, 6, 7, and 9 are present. First, Mr. Das, Land Government Advocate, has sought for further 4 weeks' time
Madam,
Four.
Four.
4 weeks time to file the affidavit in reference to the order dated 2/4/2026. The petition has already filed an additional affidavit in reference to the order dated 20/05/2026. It will
We have filed a reply with regard.
Praise the Lord, is the case on so and so. File the affidavit in terms of this. There is very specific observation in page 8 of the order dated paragraph 8, I'm sorry, of the order dated 2/4/2026. Respond to it. I'll
3107.
Number 20.
My lord, the matter relates to the corporate direction to pay compensation, my lord, due to the accident, death caused in motor vehicle accident.
No, this has been decided. Vehicle has been identified. I think division bench has passed an order.
Yes.
Division means, my lord, what happened,
Read
my lord?
appeal 170 of.
It was, my lord, challenged in appeal, my lord, and during pendency of appeal, my lord. Government, my lord, made payment of ex gratia, my lord, and therefore the matter, my lord, became infraction.
That matter was
Government, my lord, made payment, my lord. Government is
that
not
matter
fighting, my
was that matter was
Appellant
merits, Your Lordship.
The question is judgment.
Monisha Khatun writ appeal was withdrawn, Your Lordship.
Which one? This is what?
One is Honoda Das, Your Lordship. One is Parmud Ali. Honoda Das, Your Lordship, may kindly peruse.
Reject. What is 6979/2021?
That is the dismissal order of Monisha Khatun writ petition, Your Lordship.
Okay.
Thereafter, a writ appeal was
On a
preferred.
public road was hit by a speeding tractor from here and it is confirmed as a criminal offense of short relief. A strength of a notification issued in the mail to country. Is allowed or going to improve
Single bench it was a dismissal.
Parmud Ali.
Monisha Khatun also negated, right?
What is Monisha Khatun?
Monisha Khatun, Your Lordship, in paragraph,
You have provided?
no, today I have not. Monisha Khatun, I have not.
Monisha Khatun to 27. Monisha Khatun to আছে নেকি?
2700 of 2023. WPC.
Madam, 17 of Monisha.
Just a minute, just a minute. Let me just. So you know the vehicle, offending vehicle, as per the FIR,
Yes.
page 16. You know the offending vehicle. Have you lodged any, instituted any proceeding before the Motor Accident Claims Tribunal?
You must have, Your Lordship.
Yes, sir. I heard it. Your Lordship.
If that is so, then if the vehicle is identified, the division bench has observed that you should approach the MSCT for interim relief in Thanara Das. If the vehicle is identified. Where a bigger amount than what is demanded could be granted by them under no fault liability. That is the division bench observation.
My lord,
And in Monisha Khatun,
Monisha
the
Khatun.
single bench has held
Yes, Your Lordship.
that earlier judgments
Paragraph
do
18
not
has-
have any
Yes.
precedential value
Yes.
because of the Supreme Court judgment in Shashi Sharma.
Soshi Sharma and also Your Lordship, paragraph 17, 18. All these are notable, Your Lordship.
And his is found relatable to provide financial assistance to the person who is killed.
Soshi Sharma penalty in respect of government employee, paragraph 21.
Question is about judgment of the coordinate bench, whether it has held correctly or not. But for the coordinate bench, it has to follow it, or otherwise this court will have a different opinion and it will be referred to the division bench. But since the division bench has already said that if the vehicle is identified and a better relief can be obtained under no fault liability before the motor accident tribunal, and which is under no fault liability, then division bench has suggested go to the motor accident tribunal. Why should we?
In another case, Your Lordship, the Honorable Division Bench has held that at the second judgment, Your Lordship, Farmud Ali, there the petitioner's wife, Your Lordship, she had died. She was a pillion rider. She had died. She fell from the bike and she died, Your Lordship. In
But
that case,
there it observed whether it was public
Yes.
place or not, it was not asserted.
yes, Your
But
Lordship.
FIR says here must be in a public place.
Yes, Your
Otherwise, in a private place, Zolesor to Gauhati.
Yes, Your Lordship. So let's go.
Hmm?
Winger.
So it is on a public road otherwise. Charge sheet file. So it is a case of even if the offending vehicle or the claim will be third party, and third party every insurance policy covers.
Only thing is that, my lord, government my lord is paying still, my lord, even after the Monisha.
No, court has held now. Government paying or not paying is not the issue. Court has held that I have to follow the judgment of the coordinate
Due
bench.
to ignorance, Your Lordship, some officers are paying, Your Lordship. It might happen, Your Lordship.
And even
But
if-
once court has held, the coordinate bench has held, and the division bench has held, and whether you have made any disclosure regarding that, I have not approached motor accident claims tribunal.
That is, my lord. We actually on the strength of the notification, my lord, clause 3.
But clause 3 is okay. This court was passing, but now we are bound by the division bench order.
That is there.
That I cannot ignore. There is a problem.
Only point is that, my lord, because read appeal, my lord, during pendency, government made payment and therefore, my lord, the matter did not reach, my lord, ending, my lord. And
That is, some others are fortuitous. Some others are not fortuitous. Their writ petitions were disposed of early, at an earlier stage than the judgment of the division bench. Now your vehicle is, the offending vehicle has been identified. The third party insurance, which is mandatory for any vehicle to ply on a public road, must be available to the offending vehicle. And you must have pursued the remedy before the motor accident claims tribunal, which you have not disclosed. Right. And division bench has said that better remedy is available under no fault liability principle before the MSCT. So the petitioner should approach for no fault liability before the motor accident claims tribunal. Division bench says.
here, my lord, clause 3 is the case.
But otherwise, direction will be per incuriam, but it cannot be per incuriam because all the judgments have been in place now.
In that, my lord, judgment, Monisha Khatun, my lord, Gunolota and other cases were not.
Gunolota has been discussed in Monisha Khatun.
In paragraph 18, Your Lordship.
I have seen.
Yes,
I thought that earlier that Monisha Khatun was par incuriam, but it was not.
not Your Lordship. Paragraph 18.
Even that paragraph 18 I may have some objection regarding judicial obstinacy, but still I have to follow. But make a appeal before the division bench. If division bench clarifies, it is good for you. Heard Mr. A.F. I can't help it. I have to follow judicial discipline.
That is.
So you can get it clarified only before the division bench, that your case is an exception. Otherwise, I have no option.
Division bench also, my lord, wanted to know the response in regard to clause 3, my lord.
The Deputy Commissioner already sanctioned, Your Lordship. That was
Miss
in that case.
N. Goswami,
14567.
and a junior government advocate, Assam, for the respondent number 1.
4567.
4567.
And for 2 years.
Yes, and Bodoloi, and it's Standing Council Revenue Department for the respondent number, Revenue and Disaster Management Department for the respondent number 2. Any finance guy? Post of para. The petitioner is the wife of one Adil Hussain. Post of. The petitioner has stated that when at about 5:30
17/6/2000
p.m. on 17/6/2016,
16.
the petitioner's husband, Abul Hussain, was proceeding from Joleshwar to Gauhati by his personal car, driven by one Baharul Islam, another vehicle, within bracket winger, bearing registration number AS-01/DD-7627, coming from the opposite side in a rash and negligent manner, hit the vehicle where the petitioner's husband, Abul Hussain, was one of the occupants. As a result of the accident, Abul Hussain succumbed to the injuries sustained by him instantaneously, and the driver of the vehicle also sustained grievous injuries. In connection with the accident, an FIR was lodged, and the said FIR was registered as Soigam Police Station, case number 293/2016, under section 279 and section 304A. Under sections 279, 304A and 427, Indian Penal Code, subpara. The post-mortem examination reports. As per the post-mortem examination reports, all the injuries sustained by Abul Hussain were antemortem in nature, and they were caused by blunt force impact. After investigation, as per the affidavit in opposition filed by the respondent of 5, The a charge sheet under section 173(2) CRPC, Code of Criminal Procedure, was submitted on submitted by charge sheet number 105/2017 on 31/3/2017, finding a privacy case well established against the charge sheeted person for the offences under section 279, 304A and 427 IPC. Post of para. In this writ petition, the petitioner has sought for a direction in a nature of mandamus to the respondent authorities to pay an amount of rupees 2 lakh to the petitioner in terms of a notification dated as petitioner has sought for a direction to so and so as the next of kin of the deceased person in terms of a notification dated 15/11/2014 of the Revenue and Disaster Management Department, Government of Assam, which provided for disbursement of an amount of rupees 2 lakh as ex gratia to the next of kin of person killed due to accident in public places or in public carriers, within bracket, other than killed by extremist, stroke terrorist, stroke miscreants, and due to firing of security forces, bracket close. Para. It has been brought to the notice of the court that a coordinate bench of this court, a coordinate bench in Monisha in WPC number in a judgment, an order dated 21/6/2024, rendered in writ petition civil number 2700/2023, within bracket Monisha Khatun alias Monisha Khatun versus the State of Assam and others, bracket close. Consider the question whether the petitioner therein would be entitled for ex gratia compensation under the notification dated 15/11/2014, when just and fair compensation for the accident, for an accident involving motor vehicle could otherwise be claimed before the Motor Accident Claims Tribunal. Full stop. The coordinate bench has proceeded to observe that the notification dated, the provisions contained in the notification dated, the relief provided by the notification dated 15/11/2014 would not embrace all persons suffering from any accident except hit and run cases where the offending vehicle remain unidentified in the final form after police investigation. And first of the proposition which is discernible from the said decision is that a person who suffered other than the hit and run cases, comma, the persons who sustained the person who made accident, any accident, wherein the offending vehicle has been identified, would not be entitled for ex gratia as other statutory remedy is available. Post of. When an appeal was preferred against the judgment and order dated 21/6/2024
24.
in WPC number 2700/2023. Read appeal number 258/2024 against the judgment and order. So it's the division bench dismiss the appeal in taking into consideration that the ex gratia payment had already been granted to the appellant therein, and therefore there was no necessity to enter into the merits. Post. However, in another appeal, read appeal number 170/2026, within bracket another and 5 others, comma, the division bench, considering the fact that under the Motor Vehicles Act, there is a provision for interim relief to the aggrieved person has concluded the appeal by suggesting to the appellants to approach the Motor Accident Claims Tribunal for interim relief, in case so deemed necessary, where a bigger amount than what is demanded, what is permitted by the notification dated 14/11/2024 could be granted to them under the no-fault liability. With such observation, the writ appeal was disposed of on 3/6/2026. Yes, any proceeding is filed or not? MSCT. On a query made to the learned counsel for the petitioner, the learned counsel for the petitioner has fairly submitted that for a proceeding has been instituted, an application has been filed before the jurisdictional motor accident claim tribunal seeking compensation under the provisions of the Motor Vehicles Act. Pending or
Instruction, my lord.
it has been filed. It has been filed.
Disposed of, your lordship.
Well, I don't know. I cannot record that without any statement from the petition. Closed up. Whereas the vehicle has been identified as the offending vehicle, as per the materials on record, it has emerged that the offending vehicle has been identified, and the petitioner or the legal representatives of the deceased has filed an application seeking compensation before the Motor Accident Claims Tribunal under the provisions of the Motor Vehicles Act, this writ petition seeking disbursement of ex gratia payment of rupees 2 lakh in terms of the notification dated 15/11/2014 is not to be adjudicated in view of the observation made by the division bench in the case of writ appeal number 170262026 within bracket Dhananda Das versus State of Assam. Dhananda Das and 5 others versus State of Assam and 5 others. And 3 others. The writ petition is therefore disposed of in the aforesaid terms. You can approach the revision.
I have piles of documents, my lord, still government is paying. Now only.
That cannot be now.
I understand.
Revision means, otherwise I was in your favor.
Yeah, I agree. I appreciate that.
Item 22.
Pledges.
Though not laid down any ratio, but identified vehicle, so you go for no for liability.
Publishing.
So you were
May it please your lordship. Conducting counsel is in another court, so pass.
Yes, yes.
Conducting counsel is in another court.
Yeah.
Matter may be pass over.
Bring the mic to your close to you. Yes.
Conducting counsel is in another court, so matter may be pass over for a day.
No passover for the time being here at this stage. Heard, Mr.
I.L. Ngamlai.
Mr.
I.L. Ngamlai.
Learned counsel appearing for the petition has sought for listing of the case on another date. Miss P. Chakraborty, you are for? Standing counsel. Dima Hassa counsel has submitted that exchange of pleading is complete. Okay. And huh? For the affidavit in opposition on behalf of the respondent number 3 has already been filed. Post up. And the petition has not already filed, I think. Filed. Exchange of pleading is complete. Lease the case. As the exchange of pleading is complete, lease the case on so and so in the admission column.
3007. 3007. Items 23 and 24.
But one thing we must point out, though the matter is not kept as part heard, but it was heard substantially by court 10. In fact, there's a connecting PRP where there was a review petition that was allowed, permitted, and then a recall order was passed. So perhaps
There is just need an accommodation because I am being led by the Mili Ajarika. So she is on legs. So could it be after some time, you know?
Who is led? You were led by?
I am being represented by senior advocate Mili Bado.
Okay, after some time.
Okay.
Item number 25.
Lordship. Today we have filed a affidavit, Lordship.
Okay.
In this case, Lordship.
It is not on record.
Not on record today, Lordship.
Heard, Mr.
M.S. Mondal.
Petitioner.
One, yeah.
S.S. Roy, you are for?
For the state, Lordship.
Serial number?
1 and 2. 1.
Two. Or 3?
3, Lordship, M.S. M. Borman.
Okay. R. Dubey is present?
I've seen Lordship.
N.B. Castro, on behalf of Mr. R. Dubey, Learned Standing Counsel, Assam State Election Commission for the respondent number 1. Are present. Okay. Mr. Roy has submitted that. On whose behalf?
Respondent number 2.
An affidavit in opposition on behalf of the respondent number 2 has been filed today. And the said affidavit in opposition is not on record. Post of registry to trace out the affidavit in opposition of the respondent number 2, stated to have been filed today, and to release the case with the said affidavit in opposition on so and so. Ms. Borman, you are for? M. Borman. For respondent number 3. Huh?
May I prepare
Yes,
date,
after
Lordship?
that.
Okay.
Item number 26.
Lordship, they filed an affidavit on the last file, Lordship. Going to file a reply, Lordship. Which time will be granted, Lordship?
What is this case? What is the case?
Lordship, this matter pertains to the change in demographic structure, Lordship, of the particular Gauhati Panchayat, Lordship. The delimitation was exercise was completed, Lordship. There has been steep change in the population pattern. But in their record, it is the outdated record, Lordship, which we have hesitated in our petition, Lordship. But they have not mentioned anything regarding that. that particular.
Delimitation,
Not delimitation, Lordship. We are not.
what, you are in what capacity?
I'm the president of that particular Gaon Panchayat, Lordship.
Yes. President of Lama Juar Gaon Panchayat, okay. Delimitation was done,
Done, Lordship.
boundaries are defined,
Yes, Lordship.
then what happened?
But the population pattern has not been updated by the PNRD department, Lordship. It is still the old one, Lordship. The population pattern, Lordship, it is still the old one. It's not the new one. After the delimitation exercise has been completed, Lordship, there is steep change. It has been increased, Lordship, the population pattern. For which, Lordship, the GP is facing issues in regarding PMAY.
Population pattern. Say earlier it was 10,000, now it has become 12,000.
12,000, Lordship. That is not on record, Lordship. That we are agitating. We are not challenging the delimitation part, Lordship. And we have already submitted various representation, Lordship, to the respondent authorities, but they have not done anything, Lordship.
No, who are to be included, who are not to be included, who are excluded, all are in the
No, Lordship.
all are in the delimitation order.
Yes, Lordship, but in the Election Commission's data, Lordship, it can be seen that it is more than the records which are available with the PNRD department, Lordship. We have agitated that part also, and we also want to bring on record that particular point, Lordship. Also the non-voters, Lordship, because there are various schemes for non-voters which has been excluded by PNRD department, Lordship. They are only calculating the voter part, Lordship, not the non-voter part. There are various social welfare measures for non-voters also, Lordship, which has not been highlighted in their affidavit, Lordship. Also, Lordship, the affidavit has been filed by the concerned Chief Executive Officer, Lordship. It was expected that it should be filed by the Commissioner, Lordship, because he is the main person of that particular organization, Lordship. And the Chief Executive Officer has categorically denied, Lordship, that he do not possess any power, Lordship. Then, Lordship, it was no use, Lordship. They have unnecessarily filed this by the CEO, Lordship. Lordship, may I kindly come to Lordship, page number 11, Lordship.
Which page?
Lordship, page number 15, Lordship. The representation submitted by the all the elected PRS. Categorically highlighted all the details, Lordship. Lordship, in page number 18A, Lordship, the population, the voter list has been highlighted, Lordship. The translated copies.
I come to page 17. Definitely some villages are included here, some villages are included, some villages are excluded, some areas are included, some areas are excluded by the delimitation exercise. Now come to page 17.
Lordship.
Last part, impact and urgency.
As a direct result, a major portion of the Lamajua GP's population has been unjustly transferred to other GPs. This is causing beneficiary scheme and other ways the potential and precision of the holistic development.
What does it mean? As a direct result, a major portion of Lamajua Gram Panchayat's population has been unjustly transferred to other GPs. You cannot have any say on it.
We are not
Right.
taking that.
This is causing beneficiaries of key schemes such as MG, NREGA, PMY, and others to be redirected away. You cannot say anything. Leading to widespread deprivation. You cannot say anything. Potential administrative chaos and erosion of trust in the delimitation process. What, after a law, what criticism can you make? It assumes the position of law once a delimitation order has been passed. Right, this unfair situation not only hampers the holistic development of our of our GP, but also risks social unrest. This is a law and order situation among affected residents who voted and elected us based on original boundaries. In the interest of justice, equity, and adherence to the post-limitation voter list, we urgently request the population pattern rectified, restored immediately. What population pattern of Lamajua should be rectified and restored? Already prepared.
We'll bring that part on record, Lordship.
What record?
Lordship, the populate details.
Failure. What do you want to present here? Impact and urgency. Nothing.
Lordship,
Let us read again.
we are not pressing on that particular point.
No. Why should we keep it pending? After a delimitation order has been passed, you are criticizing the delimitation order, which is not permissible to be interfered with by the Supreme Court also.
Lordship.
So what this major portion of Lamajua Gram Panchayat population has been unjustly transferred to other GPs. You cannot say anything. After you get elected as a Panchayat member and president of a Gram Panchayat, you cannot criticize thereafter.
Lordship.
Secondly, causing beneficiaries of key schemes, MG and so and so, to be redirected away. They have gone to different Panchayat, they will get benefit there. You cannot espouse their cause. Leading to widespread deprivation for them. Potential administrative chaos. Erosion of trust in the delimitation process. This court in a batch of writ petitions already dismissed all those. Unfair situation not only hampers holistic development.
Lordship, kindly come, page number 18A, Lordship.
Social unrest. In the interest of justice, equity, adherence, post-limitation voter list, we urgently request the population pattern of Lamajua GP be rectified and restored. I am dismissing it.
No, Lordship, that is not. Lordship,
I am dismissing it.
Page number 18A, kindly missing, Lordship. Lordship, here we have highlighted the voter and the non-voters details, Lordship. That is not contrary to the details of the PNID, Lordship. That is why we have highlighted this part, Lordship. That's what I am not.
What? If I go more into it, then I'll find more. Let us see in the table below. You are Panchayat President. Okay, then imposition of cost is required. Criticism of delimitation process invites cost. Non-voters cannot be included in the voter list.
Not
And there is a process for inclusion of voters.
Lordship.
They are not agreed. Who are you?
Lordship, they have approached us.
Who are you, sir?
Lordship, they have approached us and we are filing on the.
Let them file.
Lordship, they are the Gav Panchayat.
You are not here to espouse their cause. This is not a public interest litigation.
No, Lordship, no, but they are the voters of my Gav Panchayat.
That is a different issue. Let them approach. That is a cost-effective exercise.
Lordship, they have approached us, Lordship.
No, The voter, if his name is excluded from the voters list, he can approach the what Representation of People Act and that. He can approach.
Lordship.
Who are you? And that is a cost-effective exercise. That does not entail any cost. That you will espouse their cause as a public-spirited person.
No, Lordship, as a local
I'll
representative.
impose cost.
No, Lordship.
10,000.
No, Lordship. Kindly be
Hard.
Yes, sir.
No. This is absolutely.
Lordship, one last opportunity may be given. Lordship, we'll highlight
Lama
that-
Juar, okay, Lama Juar Gaon Panchayat by Aini, Be Aini, delimitation Pratibadi Mancho had earlier approached this court against the delimitation process.
We are not on delimitation, Lordship.
No, you're criticizing.
Criticism,
Now you're, because of your criticism,
that is, they are political
because of
opinion.
your criticism of the delimitation process.
That is, they are political views, Lordship.
Hard.
No, Lordship.
No, this is not done.
Lordship, I
As if you are a public interest litigant.
No,
Hard.
Lordship, as the voters approach us, Lordship, with, for that only we have filed it, Lordship. We have a bona fide intention, Lordship.
No bona fide intention. Criticism of the delimitation process is no bona fide intention. Mr.
Yes, sir.
This kind of petition should be taught a lesson. After getting elected with the
No,
electorate.
Lordship, that is their political opinion, Lordship. We are not.
No, it is a political, politically motivated writ petition. If you make more submission, I'll observe so. And Miss P. Thapa, learned counsel on behalf of Mr. S. Dr. Learned Standing Counsel, Panchayat and Rural Development Department for the respondent number 1 and 2, Mr. and 4. And Mr. S. Roy, Learned Junior Government Advocate Assam for the respondent number 3, full stop, para. The petitioner has stated that in the recent Panchayat General Election, Kamasi got elected as a ward member of 9 number Lama Juar Gaon Panchayat. And pursuant to a resolution taken in a meeting held on 22/07/2025, the petitioner has been was declared elected as the president of the Gaon Panchayat. In this writ petition, the petitioner has stated that the writ petition has been filed in a representative capacity to agitate the issue of apparent discrimination in distribution of funds proportionate to the entitled population and to assail the arbitrary action on the part of the respondents. The petitioner is stating to have espoused the cause of deprivation of a large number of population from the government benefits. The petitioner has stated that she is compelled to approach this court, invoking the extraordinary jurisdiction of this court under Article 226 of the Constitution after the representation submitted by the petitioner did not evoke any response from the respondent authorities. Full stop. Para 1 of the representation enclosed with the writ petition is at Annexure 2. In the said representation submitted by the petitioner before the respondent number 2. The petitioner presenting some datas. After the delimitation process of Gaon Panchayat, Anshalik Panchayat and Jilla Parishads in the state of Assam. Has canvassed that as a direct result of the delimitation process, a major portion of Lamajur Gaon Panchayat's population had been unjustly transferred to the other Gaon Panchayats, and the same has caused the beneficiaries of key schemes such as MG Enrega, PMAY and others to be redirected away, leading to widespread deprivation, potential administrative chaos, and erosion of trust in the delimitation process. Most of the unfair situation created by the delimitation process has not only hampered the holistic development of the Gaon Panchayat, but also has given rise to potential risk of social unrest among affected residents who voted and elected the ward members of Ramajuar Gaon Panchayat, including the petitioner as the president of the Gaon Panchayat based on original boundaries of the Gaon Panchayat. In the representation, the petitioner, the representationist, including the petitioner, had represented that the population pattern of Lamajur Gaon Panchayat be rectified and restored immediately in the interest of justice, equity, and adherence, and the failure to act would result in irreversible harm to thousands of families. Full stop. The representationist had sought for conducting an investigation for corrective orders. Full stop. Para. In a batch of writ petitions, including WPC number, including WPC number 5346/2024. This court, by judgment and order dated 24/4/2025, in a batch of writ petition, including so and so, the exercise undertaken by the state respondents as delimitation exercise for delimitation of Gaon Panchayat, Anshalik Panchayat, and Jilla Parishads in the state of Assam was assailed by judgment and order dated 24/4/2025, passed in the said batch of writ petition, this court has held that has appealed the process of diminution of Gram Panchayat, Anchalik Panchayats and Zilla Parishads in the state of Assam. The delimitation order has already been published in the official gazette. The issue of the infringement of the rights of the electors associated with the delimitation process of panchayats and election to the panchayats have been were examined, and it has been held that any of the those petitioners' rights associated with the delimitation process of panchayats and election to the panchayats and the contentions regarding the rights associated with the delimitation process of panchayats and election to panchayats have been negated. Full stop. Para. In view of the projection having been considered by this court is found to be misconceived. The petitioner is found to have canvassed regarding criticized the delimitation process and has canvassed about erosion of trust in the delimitation process, raising an issue of risk of social unrest among the affected residents affected by the delimitation process. First of para, the writ petition is found to be a misconceived one, and in such view of the matter, the writ petition is disposed of, is dismissed with a cost of rupees 10,000, which is to be deposited by the petitioner before the registry of this court within a period of 10 days. In the event of such deposit or rupees 10,000, in the event of such deposit, the said amount is to be, registry is to transmit the said amount to the Gauhati High Court Bar Association. immediately thereafter.
Lordship, that way, got that, Lordship. Lordship.
20,000.
No.
May we take your lordship indulgence, my lord. Item number 23 and 24, in fact,
Yes.
although it is not a part heard, my lord, we have confirmed. Well, I was under the belief that it matter may not be taken up. So can it be taken up any day, my lord, convince your lordship tomorrow, day after, or any day? My lord?
Not before vacation. I already tied up. I have fixed few matters.
As your lordship pleases, my lord. Not today, my lord. That is my prayer, my lord, not today.
And hardly few days are there.
Yes.
23rd.
Immediately,
An attempt on the 23rd, Lordship.
not possible.
And let it come
Not
after
possible, that is why.
After vacation.
Otherwise, I would have
Vacation.
answered in the request.
I'm sorry. Lordship, any day after the vacation then?
Okay, 16, 18, you can have it.
You take week next.
Okay.
July.
Lordship, around 23rd of July.
Kiba আছে 23rd. আগত দিয়ক 16, 18 is possible. 16 is possible.
Right.
Fine, fine.
16 July.
Oh, yes.
Okay.
Highly obliged.
M.K. Choudhury, Senior Counsel, appearing for the
Petitioner.
petitioner in so-and-so, and Miss M. Hajorika, Learned Senior Counsel for the respondent number 2. And government advocate. Okay. Okay. And Mr. Deka, you are for? In review.
IA in the CRP. There is a
IA. IA was for?
was for recalling.
That has already been.
Okay. And this, what is this review petition?
The reviews are done and dusted, Lordship.
But they say there is civil
Okay.
division which survives from.
Only the civil.
Which was tagged with the WBC.
The reviews are done and dusted.
Okay. In the read petition earlier, there was a judgment.
Yes.
For what?
Yes.
That has been, review petition was preferred.
Oh my God.
Respect of a
In this
CRP.
petition, there is no judgment.
Now only the CRP is surviving.
Which was tagged with the WBC.
Which was tagged with the WPC.
An offshoot of
Okay.
the.
Present as sought for and agreed to by the learned counsel for the parties, list the cases on to 16/7, 2026.
Obliged.
Highly obliged.
Respondent number 2 and 5, they have filed their affidavit in opposition, Lordship. Perhaps, Lordship, affidavit filed by the respondent number 2 is not in record, Lordship, perhaps. As per
Respondent number 2.
Revenue Department, Lordship. As per their stamp, Lordship, the petition.
Yes, Mr. Bhattacharya. Your file? Not on record.
Not at all.
Okay, Mr. G.R. A. Mubarak, learned counsel for the petitioner. S.S. Roy.
1, 4, 5, 6, and 7. We have also filed.
And Miss Anne Bodole.
Today, it's fine to.
Okay. Now standing counsel, Revenue Department for the respondent number 2. Present. Affidavit, the affidavit in opposition of the respondent number 5 is on record. Post of it is submitted that an affidavit in opposition of the respondent number on behalf of the respondent number 2 has already been filed yesterday. And the said affidavit is not on record. Post of as the affidavit of the respondent number 2 stated to have been filed yesterday, comma, is not on record, comma, registry to trace out the same and raise the case on so and so, it does say affidavit on record.
1507.
Nemo. Learned standing counsel, revenue department be reflected in the respondent side the cost list.
Can it be on 14? 14?
14 to
Next date, 16?
17.
7.
Item 30.
Lordship, in both item number 30 and 31, already copy of affidavit sent for swearing. So
Okay. HR Ahmed petitioner. A authorized revenue 1 and 2. HK Hazarika 345. Mr. Hazarika submitted that the affidavit, draft affidavit in opposition.
Respondent.
Of the respondent number 3, 4, and 5 has been sent for vetting, and if the case is listed after 3 weeks, the affidavit in opposition will be said affidavit in opposition will be filed. The prayer is allowed to list the case on swings. Same in 31.
Yes. 2207. Item 32.
Earlier, the action was to file affidavit by enclosing report of the electrical inspection.
Here I received the instruction that we require some time, we are preparing the report. Lord. Let it come up first week of August.
So, electrical accident inquiry report. Okay, D Bora petitioner. Who is for APDCL? Mr. S.S. Roy, learned junior government advocate for the respondent number 4 and 5 are present. Mr. Roy has submitted that the electrical accident inquiry report will be brought on record on with the affidavit of the respondent number 4 and 5. And for the same comma, he has sought for 3 weeks time to file the said affidavit. The prayer is allowed to release the case on swings.
He said that after vacation. August. August.
All right.
Item 33.
Maybe.
Lordship, there is a direction on last order to file extra copies, so still we not get any copy.
Mr. J. Islam, counsel for the petitioner, shall furnish extra copies of the writ petition along with annexer to Mr. Yusokia, learned counsel for the respondents by tomorrow, so as to enable the respondents to bring their stand in their counter within 3 weeks' time. List the case on swings.
Item 34.
Yes.
Your Lordship, on the last occasion, I have been directed to file my response. So Your Lordship, 1 week maybe.
1 week, but 1 week will go after vacation then.
Sorry.
What vacation?
S. Islam petitioner and M. Sharma 1 to 3. S.S. Roy 4. Mr. Sharma has submitted that he is yet to receive the necessary instruction to file the counter affidavit and has sought for 2 weeks' time to obtain the necessary instruction and to file the counter affidavit post of the respondent. Bank authorities shall also bring on record as to whether for what amount direction has been received for keeping the bank account freezed.
On his request only, I have received the instructions. On his request, it was closed because some fraudulent activities were
By some other person.
But
One
he
account,
had informed the police too.
I have given a complaint that fraudulence is committed by someone, that one account, second account, it is without my knowledge, without. I have lost an affair. I have annexed the documents.
That he had given his credential to some of his friend to operate the account. Thereafter, he filed an FIR to freeze the account.
Electrical accident report 2. 7 August.
से भी कंप्लेन ये सब जगह से इंस्ट्रक्शन क्लोज करनी होगी उस अकाउंट से पैसे 18-19 अकाउंट फ्रीज किसी अकाउंट से पैसा दिया एक लाख का प्रोसेस
Well, looking the same is also 9 years. It is used. Have you seen the message?
As per the report, it is your own creation. It looks like your own creation. Whatever, but it is a case of 19 number of complaints.
Yes.
From all over India. I don't know whether any state is left out. Gujarat, Maharashtra, Punjab, Madhya Pradesh, Uttar Pradesh, Rajasthan, Kerala, Maharashtra, Tamil Nadu, West Bengal, Telangana. Any state is left out, I don't know. And it is your own creation. You are in direct link with all these persons. A number of arrests have been made. And your own admission that I have allowed the bank account to be operated by these persons. File give this all these annexa in your affidavit. And such it has already been submitted. Mr. Roy, you also bring the record. Both of you are granted 2 weeks time. Mr. Roy has submitted that he has received the necessary instruction to file the counter affidavit and has sought for 2 weeks time to file the counter affidavit. Let the counter affidavits be filed within 2 weeks time by the responding authorities. This is the case on sense.
28th July.
Serious, your case is serious.
35.
Please, Lordship, I have filed an implement petition, my lord. But yesterday it was got the serial number. It has not tagged with the file, my lord.
Okay, MU Mahmood, Learned Counsel for the petitioner has solved listing of the case on Wednesday. On the submission that an interlocutory application seeking implement of a necessary party has already been filed. List the case accordingly on so and so with the interlocutory application. Mr. M. Sharma,
For Central Bank.
Mr. S.S. Roy, 1 and 3, and M. Sharma. Order 2 are present.
2406.
Obliged.
Supplementary list, item 51.
This court on 15/6/2026 passed the following order. Had passed the following order. Today also, when the case is called up, none has appeared for the writ petitioner on call in view of non-representation on behalf of the petitioner on 2 consecutive occasions. This court is persuaded to form a view that the petitioner is not interested to pursue the petition. Therefore, the petition is dismissed for non-prosecution.
Items 52 to 62.
Yes, Mr. Das, what did you say? I put on Das or to the option. Yes, Mr. Chetia, is it different from the other batch?
Yeah, ask me. Even my lord, that ground also, my lord, they have taken the my lord issue of whether the jurisdictional assessing authority or the my lord the faceless assessing authority. That ground is also there, my lord, in the writ petition. So the broader question, my lord, remains same, my lord.
Let it remain.
So ground number.
Is it a case of faceless?
Yes, my lord.
In your case, no, I am just not as a whole patch.
Lord,
let us see what is your ground.
But at page 16, my lord, ground
And
number.
there is an administrative order also.
Yes.
Your Honor, she wants to make some mention. I don't know. She's insisting on mentioning. I don't know what.
Madam, please wait. When the court has asked Mr. Das to address, don't interrupt in between.
Yes, Your Lordship. I'm very sorry. I'll be careful from the next time.
Yes, is it a case of just faceless all these issues?
Yes. In the interim order.
First prayer is that only. First prayer is prayer number 1 is that only.
My lord, yes. Prayers.
And related to 148.
Yes.
And there is a common order by the Honorable Chief Justice.
Lordship.
Mentioning all this.
Lordship, may I pray this part? Lordship,
Okay, we'll hear you out.
Because the
And this has been specifically assigned to this bench.
Yes,
So I have no
I'm
other
not
option.
on the assignment, Lordship. Lordship, in this case, I'm being led by Mr. Nishit Gandhi. So I just had a word with him. He, in fact, had told that he was there in the Supreme Court matter as well. So he was the counsel there. So if Lordship allows me to let him address to this point whether this will be a part of it. If that much accommodation is given day after tomorrow or tomorrow, any day, just on that point whether
Let us hear.
That's the only prayer.
Man will decide. Now, yes. So what is this one IA is there?
I has been filed by me, Lordship.
IA.
Is the IA
Filed
IA has been filed in view of the Supreme Court's order to bring
Okay.
record because this matter was already disposed of matter, Lordship.
So that will be restored.
Yes.
That is required to be restored because by that order,
Yes.
the writ petitions were
Asked to be
that issue.
dismissed and their stay orders also will go. And the time period, Your Honor.
1 minute. Let me find out about the IA first.
The IA.
IA logot main writ petition disposed of the sound disposed of 2438. 2438.
Yes.
What order it was?
My lord, the relevant order is at
No, where is that Supreme Court order?
134. Relevant part is at 134.
No, I have not found that order.
It's annexed at with the IA, my lord.
No, it was in loose form. Put to the seal.
It's annexed with the.
খুলি গৈছে নে কি কৰিছে খোলা আছে এইটো এটা আৰু এটা আছে নেকি This is 2438. Chief Justice or even a note at us. Chief Justice or oh, it does. Oh, it is in another file. 1138.
Okay, okay.
Taste part of Singh.
Yes, my.
Taste part of
Yes,
Singh.
yes.
Para 22.
Para 22. In fact, my lord, the IA also is around the whole this Supreme Court judgment only.
No,
It-
other writ petitions are not decided.
No,
Only this has been decided.
Tej Pratap Singh has been decided.
No, Tej Pratap has decided, and paragraph 22 in Tej Pratap Singh,
Yes.
it says that since the High Courts have primarily quashed the reassessment notice on the ground that the JAOs
Yes.
lack competence to initiate such proceedings,
Yes.
and the very foundation of that view now stands altered by the amending legislation,
Yes.
the impugned judgments in favor of the SSC are set aside.
Yes, yes.
So only this was decided,
This was decided.
that is 2438.
2438.
So that is to be said that in view of the judgment of Tej Pratap Singh by the Supreme Court,
Yes.
that the order stands set aside.
Set aside.
And it is to be restored to its original number.
Yes. Yes.
Right.
Yes.
This is the shortest way.
Yes.
Right.
This is the
Other writ petitions are also on the same ground,
same ground.
that faceless and JAOs, who has the competence to
To
148 to 148A and 147, something like that.
Yes. Yes.
Is it not?
Yes. Yes.
And second
Absolutely
is,
correct.
in none of the cases, amended application is filed.
Filed.
That limitation gone.
Gone. Yes. Yes.
So we have to decide on it.
Yes. And Supreme Court has specifically said that no more time. 1 month's time was given to them. That
is gone.
That is gone. 27th of.
I cannot alter that period.
Yes, that is gone, and they have not availed that. So now this writ petitions has to go, and the officers will be given the power again to do the process.
Yes.
May I interject, my lords? I am appearing in 3 petitions listed today. My lord, the Supreme Court order is only limited to the petitions which were before the Supreme Court on the given day when this judgment has been passed. It is not an omnibus order which would be applicable across all the pending petitions. That is an incorrect my lord's, interpretation on the part of my learned friend.
So what does it say at paragraph 20?
My lords would see para 22, 23 and 24.
No, first let us see then.
Yes, my lords may see para 5 first.
At the beginning.
Yes, paragraph 5. Or para 1, on oral mentioning, diary number so and so are taken on board and heard along with this batch of matters. In a nutshell, the genesis of this batch of thousands of appeal originates from reassessment proceedings initiated under IT Act. The impugned judgments of several high courts have set aside orders passed under 148A clause D and consequential notices under 148 on the ground that they were issued by the jurisdictional AO, which is JAO, rather than...
May I know your good name?
Yes, my lords. I am Prakul Khurana.
Okay. Firstly,
Yes.
we are concerned with this already disposed of writ petition.
Yes.
Right.
Yes. So now, my lord, the question before your lordship would be whether if they have preferred a recall application, because whether that can be accepted, unless, my lord, they assail this order before the Supreme Court. It says it is pertinent to note that certain other high courts, while considering the same issue, have adopted a contrary view and upheld the authority of the JAO. Given the common question of law involved and the divergent views expressed by various high courts, we propose to dispose of this batch of matters by this common order. So it is only qua this batch of orders, these batch of petitions. Then they discuss the background, the law, everything, how it evolved, how the earlier notification came, and how the courts have taken this view. Then, my lords, para 22. Or para 20, I would read that. Para 20 onwards. In all fairness, we may add that several other contentions have also been raised by both sides, which we do not consider it necessary to advert to at this stage in light of the order we propose to pass. In the facts of the present batch, we are of the considered view that it is not necessary for this court to examine the merits of the rival submissions concerning the correctness of the impugned judgments or the scope of the competing precedents at this juncture. It appears to us that the assessees would be entitled to challenge the amending provisions as elaborated upon heretofore, for which it would only be appropriate to relegate them to the jurisdictional high courts. All contentions raised before us, as well as any other grounds available to them to question the impugned notices, may be urged before the high courts instead. Since the high courts have primarily quashed the reassessment notices on the ground that the JAOs lacked competence to initiate such proceedings, and the very foundation of that view now stands altered by the amending legislation, the impugned judgments in favor of the assessees are set aside on this limited ground. The matters are accordingly remitted to the respective high courts for fresh consideration or ordered accordingly. The assessees are granted liberty to amend their writ petitions if so advised within a period of 4 weeks from the date of uploading of this order, so as to enable them to lay challenge to section 147A as introduced by Act number so and so of 2026 or to any other connected or consequential provision. Similarly, the appellant revenue shall be at liberty to file their written submissions and affidavits before the jurisdictional high courts within a period of 3 weeks thereafter. No additional time shall be granted to the parties beyond what has been granted above. We make it clear that we have not expressed any opinion on the merits of the controversy, including the validity, scope, effect, retrospectivity, or applicability of the amended provisions, and all such questions are left open to be decided by the High Courts. Finally, during the pendency of the writ petitions before the High Court, there shall be an interim stay of further reassessment proceedings pursuant to the impugned notices, subject to such terms and conditions as may be imposed by the High Courts. The High Courts are requested to decide the matters preferably by 30th September 2026. Learned counsel for the parties undertake to extend full cooperation to the High Courts in this regard. No adjournment may be granted by the High Court on mere asking of the parties. The registry shall transmit a copy of this order to the Registrar General of the concerned High Courts. So, my first submission is this order is only qua those petitions which were before the Supreme Court, in which the order has been passed. It is not qua the pending petitions.
Okay, in the IA, whether this that judgment rendered in 2438 was this in the batch of thousands of writ petitions?
Yes, ma'am.
Okay, let us see. IA. Which page? Any SLP number?
SLP number was there. Paragraph 3.
So far that appeal was preferred against the judgment of this court in that writ petition 2438/2022. So by operation of paragraph 22, that judgment has been set aside. So that is not in your case, but who is the
That's right,
petitioner?
If that is the case, then of course it is set aside.
They have given the diary number. That petition was, that appeal was part of that 1,000 batch of writ petition.
Right, Mullah. In that case, then the order stands set aside. It has to be heard, and the opportunity to amend the petition has to be given to the respective petitioner, Mullah, in that case.
So those observations are for them only.
But
The batch of
That's for them.
repetition.
my lords. Yes, my lords. For them. For them.
But
Who is the council in 2438/2024? In the IA. In the IA. IA is OP Bhatti. Yes.
I am the petitioner.
Yes.
243.
Now, that was, your judgment was appeal.
Yes, Lordship.
And that will be part of that common judgment in Tes Pratap Singh.
Yes, Lordship.
By that judgment, this judgment has been set aside. So, this IA is to be allowed, and writ petition 2438 is to be restored to its original number. Right? This is one. Let us allow this IA.
yes.
First, heard Miss M.L. Gopal, Senior Standing Counsel, Income Tax Department, for the applicant. And Mr.
P. Sharma.
B. Sharma, Learned Counsel, for the opposite party. Sole opposite party. Applicants, Applicants. Full stop. Para. The instant interlocutory application is preferred to bring on notice an order an order an order dated 10/4/2026, passed by the Honorable Supreme Court in a batch of thousands of appeals, including one civil appeal with diary number 2196/2026 within bracket income tax officer, ward 2 within bracket 1, Chandigarh and others versus Tes Pratap Singh. Full stop. Para. The sole opposite party as the writ petitioner preferred a writ petition WPC number 2438/2024. Assailing the legality and validity of an order dated 26/3/2024 issued under Section 148 capital A of the Income Tax Act 1961 as amended, and a notice dated 26/03/2024 issued under Section 148 of the said Act by the Income Tax Officer. Full stop. The assailant is made. The assailant is made on the ground that the impugn order dated 26/3/2024 was passed by the ITO in gross violation of the provisions contained in Section 130, 144B and 151A of the Income Tax Act as required by the provisions to be in faceless manner. Full stop. Para. The writ petition came up for consideration on 20/05/2024. And after hearing, and taking into consideration The provisions of Section 151 of the Act and the scheme, income escaping assessment scheme, 2022. Notified by notification dated 29/3/2022. The court.
E-assessment of income.
Hmm?
E-assessment of income escape.
E-assessment of income escaping assessment scheme 2022. The court. It observed that the scheme was for the purpose of assessment, reassessment and computation under Section 147 and for issuance of notices under Section 148. Are to be carried out through automated allocations. The writ petition was disposed of by an order dated 20/05/2024 with a liberty to the departmental authorities to proceed issue fresh notices upon the petitioner to issue fresh notices so as to enable the petitioner to file their appropriate reply under the provision of Section 148. Full stop. In this interlocutory application, in the order dated 10/4/2026, the Honorable Supreme Court the order dated 10/4/2026 was passed by the Honorable Supreme Court in a batch of thousands of appeals originated from different high courts. The Honorable Supreme Court, after considering the provisions of the scheme and the related provisions regarding automated allocation and faceless mechanism, where is the finding?
Finding starts from 134 page.
Hmm?
From paragraph 22.
Had observed that since the High Courts had primarily quashed the reassessment notices on the ground that the jurisdictional assessing officers within bracket JAOs lacked competence to initiate such proceeding. And the very foundation of that view stood altered by the amending legislation comma, finance, which Finance Act, 2000?
Amendment has been made by Finance Act 4 of 2026. Paragraph 23, it's written. Paragraph 23 of the judgment.
Well, somewhere it is mentioned.
Paragraph 23, it is mentioned, Lord.
Which Finance Act? No.
Finance Act introduced by Act 4 of 2026.
By Act number 4 of 2026. The judgments, the judgments, impugned judgments, delivered in favor of the SSs were set aside on such limited ground, and the matters were remitted to the respective high courts for fresh consideration. First of para.
My lord, one paragraph.
In this,
But my lord, only one paragraph, paragraph 25, which says that no additional time shall be granted to the parties beyond.
no, we are not into, we are allowing this IA only.
Yes.
In paragraph 3 of the application, it is averred that against the judgment and order dated 20/05/2024 passed in WBC number 2438/2024, the department had preferred an appeal before the Honorable Supreme Court, and the same was registered as diary number 34788 of 2025 within bracket Union of India versus Ram Narayan Shah. And the said diary number was one of the thousands of appeals wherein the order dated 10/4/2026 was passed by the Honorable Supreme Court. First of all, in view of the said fact, comma, the order it is to be observed that the judgment and order dated 20/05/2024 passed in WBC number 2438 of 2024 has been set aside by order dated 10/4/2026. So as a result, consequently, this interlocutory application is to be allowed. It is ordered accordingly. As a result, comma, the writ petition WPC number 2438/2024 is to be restored to its original, is to be restored on record. First off, in the main 2438/2024. Okay, is to be restored on record. Yes. And now the other batch, the IA is allowed. So as a whole, this 2438/2024 and other batch of writ petitions, other writ petitions. What orders to be passed? Now, are you ready now?
Yes, my lord. My lord, item 52 is one of my petition, my lord. But that
Now, what is the consequence of this order? This
Because
order was that regarding pleading.
Yes, yes, my lord.
That was confined to those batch of writ petitions.
Lot.
Now, would you want to file any response in this batch of read petitions.
Lordship, yes, my lord. In fact, my lord, in other read petitions, my lord.
I'm sorry, I have forgot your good name.
It's Prakul Khurana.
Purana.
Yes.
Okay.
So far,
So far as they have challenged the process here.
Lordship, lordship,
Hmm?
lordship.
They have not challenged the virus.
My lord. Yes, yes. So, my lord, after
Basically, first let me find out.
Lordship.
They have challenged the process,
Lordship,
not the virus.
my lord. Yes, lord.
If they have challenged the process only, it will be before this court.
Lord.
If by way of amendment, they challenge the virus, then this batch of read petition will not be here.
My lord, my lord. Lordship.
Now it is, make your submission.
So, my
The
lord.
read petitioners.
Yes,
If
my lord.
they,
My lord, yes.
if you want to say the process adopted under section 148, 148A is bad or something like that in this batch of read petition, it will remain here.
That's right, my lord.
But coupled with the process, if you want to challenge the virus,
Yes.
Whether I have not gone through any of the repetition, whether the virus has been challenged. No, my lord. In other petitions,
But
no.
so far, it has not been challenged. But my lords, in the pending writ petitions, my lords, the petitioners have to urge your lordships to grant them time to challenge the virus.
No, it is up to you. Virus can be,
Yeah.
there is no period of limitation for challenging the virus.
That's right. That's right.
Right. That is
Yes,
up to
ma'am.
you. And
Yes,
you
ma'am.
can challenge it independently.
Yes, ma'am.
Notwithstanding this batch of writ petition, wherein you can include the other prayers.
Yes,
But
my
if
lords.
you want to amend here, we have to amend after allowing your amended petition. Thereafter, I will say that this court has no jurisdiction to decide virus because it is to be before a division bench.
That's
So
right.
it,
my lords.
so it is your choice. I have
So most of the high courts, now the text matters goes to the division bench.
now
But
here
my
it
lords,
is a different.
yes,
No,
here
if
it goes to the SB. Yes.
if the virus is not challenged, it is before single bench.
Yes, my lords. Yes.
Every court has different.
That's right. That's right.
My lord, in some of cases, lordships, in item, I am representing item number 52 and 62, my lord. There, my lord, we have to file our affidavits, my lord. It's a new case, my lord. We already received para-based comments. We'll file our affidavits. And in all the cases, my lord, virus was not challenged as on date, my lord. So, my lord, after this amendment, my lord, in 2026, my lord, after incorporation of section 147A, my lord. So, in other cases also, we need to file an additional affidavit, my lord, by pointing out this amendment has already been made. So in
Whatever
that,
you want to file, you file by
Lordship. So in that circumstance,
on or before 20th July.
Lordship.
20.
So my humble submission, my
07.
lord, let the matter be adjourned today, my lord. In the meantime, we will file our affidavits.
But you file your response
My lord.
in all the batches.
Lordship.
And we'll try to stick the deadline. Though, except this one,
Lordship.
no other
Certainly.
repetitions
Yes.
were before the Supreme Court in Tez Pratap Singh.
Lordship.
But this was there, 2438.
Lordship.
So it has to be decided within that deadline.
Lordship.
Right?
My lord.
We'll also try to decide the other also within that deadline.
Yes, lord.
Plus, may I just submit one thing? Plus, item 52. Plus, item 52, no grievance survives because there is an assessment order. I have the instructions that the assessing officer has accepted the returned income and therefore no grievance survives as on today. So, Mulaz, I seek liberty, Mulaz, to withdraw this with liberty to approach if any grievance revives in future. So, item 52,
So in
your
the
lordships
event
can
of
dispose of.
fresh cause of action.
Yes, Manoj. In case of Manoj, we don't know they have the power of revision. If they tomorrow revise
So that will be
assessment
fresh
order,
cause
then
of action.
yes, Manoj.
Okay.
Your lordships may observe this.
Heard Mr. Khurana.
Yes.
One submission. My lord, in all these writ petitions, my lord.
No. First 52.
52.
He wants to withdraw with liberty.
Yes. Then otherwise they have to challenge the others. Have to challenge the.
No, only 52. Mr. Khurana is saying that as on that he has got the relief. But
Yes.
in the event any fresh cause of action, he should be granted liberty. Any objection? No. Okay. Mr. K.R. Khurana,
Prakul Khurana.
P. Khurana, learned senior counsel.
No, my lord, I'm not senior.
Learned counsel, assisted by Mr. S. P. Khurana,
Swati.
learned counsel through the virtual mode, with Mr. S. Day, learned counsel for the petitioner, and who appears in item
Lordship,
number 52.
in 52, I am appearing, my lord, for respondent number 2 and 3.
And any CGC, Mr. S. Setia, okay, A.K. Doctor, learned counsel, central government counsel for the respondent number 1. And Mr. S. Setia, senior standing counsel, Income Tax Department for the respondent number 2, 3, and 4. So Mr. Khurana has submitted that during the pendency of the writ petition, the relief sought for by the petitioner, sorry, the grievance of the petitioner has been mitigated, and therefore, the petitioner does not want to pursue the writ petition at this stage and wants to withdraw the writ petition with the liberty to approach again in the event of any face cause of action.
Very well.
So, in view of Mr. Setia, Mr. Dotto and Mr. Setia have submitted that they have no objection to the prayer so made. In view of the above submission made by the learned counsel for the parties, the writ petition is dismissed on withdrawal, with the liberty, as prayed for. 52.
Yes,
Only
please.
52.
Yes, plus 54 and 55, my lords, I seek liberty to amend the petition, my lords, challenging the wires.
Okay. Mr. Setia, you appear in which item?
My lord, 53 and 54, lord.
Mr. S. Setia, itu belag order. Huh?
50.
Mr. S. Setia, who are the petitioners? P. Khurana.
Yes, Mr. I'm for 54 and 55.
And Mr. along with Mr. S. Day, learned counsel for the petitioners in 54 and 55.
Yes, ma'am.
Mr. P. Sharma, learned counsel for the petitioners in 56, 57, 58, and 59. Mr. R. Goenka, learned senior counsel, assisted by learned senior counsel for the petitioner in 60. Who is in 61? No, petitioner side. Petitioner side. ML Gop cannot appear. So who else? S. K. Saha, learned counsel for the petitioner in 61, and Mr. R.J. Das, learned counsel for the petitioner in 62 are present. Mr. No, I am not right. Petitioner's name. Why disturb in between? Mr. S. Setia, learned senior standing counsel, IT department for the respondents in
54, 55, and 62, my lord.
54, 55, and 62. Okay. Dr. B.N. Gogoi, learned standing counsel, IT department for the respondents in
All the in contact.
Till the item numbers.
Item number 60 and 61, my lord.
60 and 61. Who else? You are income tax? Income tax. Mr. Learned standing counsel, junior standing counsel, income tax department for the respondents in item 58. Who else? ML Gop, learned senior standing counsel.
I'm also senior standing counsel, sir. 60 and 62. That have been reflected.
Hello. When I was asking Miss Gop, then why you interrupt? Senior standing counsel for the respondents in
53 and 56.
53 and 56. B and Google senior standing counsel are present. Full stop. In all the writ petitions, no IT department counter has been filed?
No, we filed it.
Huh?
My lord.
Okay, tell me now.
No, in 60,
You have not filed. Where you have filed?
Yes, my lord.
Response.
My lord, 54 and 55.
In the, against the writ petition, presently existing pleadings in the writ petition.
Lord.
Okay. Mr. Chetia has submitted that counter affidavits have already been filed in
Item number 54 and 55.
54 and 55.
My lord.
Mr. Gogoi,
61. Item number 61.
Dr. Gogoi has submitted that. Baki nalage, namtu likhibo nalage. The Land Standing Council appearing for the respondent Income Tax Department authorities have submitted that counter affidavits have already been filed in Chetia,
54 and 55.
54, 55. Mr. Gogoi,
61.
61. Anywhere else?
Yes. Yes, but in item number 57 and 59.
Income tax.
Income tax. In your
Likhok. What is the number?
57 and 59.
57 and 59. So stop. The Learned Council Standing Council appearing for the respondents in the remaining writ petitions wherein no counter affidavit has been filed, have submitted, have sought for time till 20/07/2026 to file the respective counter affidavits. The respondent authority, IT department authorities shall ensure that their respective counter affidavits is filed on or before 20/07 or before 20/07/2026 without fail.
Lord.
Done?
My
lord.
Mr.
There was interim order in item.
Last. Mr. Khurana has
Your Lordship.
submitted that he may be allowed to file additional pleadings in the meantime,
Very well.
wherever necessary.
Very well.
It is up to you.
I'm so grateful. I'm so grateful.
And first of list the cases on
The same may be granted. Same may be granted in 62.
okay, Ajay Das. You are not with Khurana.
No.
Okay. And Mr. Das. Ajay Das. I have sought etu kolu na logot add kori dibo. List the cases. On 20/07/2026, the interim orders, wherever passed earlier,
Yes.
shall continue till the next date of listing.
I'm so grateful. Deeply obliged.
Anybody's name is missed? I hope not.
Deeply obliged.
May I please your lordship? My lord, item number 51. My name may be reflected as a respondent number 1. It was dismissed, writ petition dismissed, my lord, due to default of the writ petition.
Okay, Mr. I. Taludar, Learned Counsel for the respondent number 1 is present.
Yes. Obliged.
Anybody else's name? Okay. Yes, next. Admission হয়ে গেল না?
For orders, item 43.
36 কি হলো?
36, sir.
Mondal, wrongly called.
36.
Sorry. 36. Item 36.
Last occasion.
Will dismiss. Otherwise, merit also maybe 36. No, will not observe on merit. Why should make the labor? There is no representation on behalf of the petitioner today on call. On the previous date of listing, On 1/6/2026 also, there was no representative on behalf of the petitioner on call. Post of Mr. S.S. Roy, Learned Junior Government Advocate for Assam for the respondent number 1, 4, 5, 6, 7, and Miss Ann Bordoloi, Learned Standing Council, Revenue and Disaster Management Department for the respondent number 2 have submitted that in this petition, the petitioner has sought for a direction to release a sum of rupees 2 lakh ex gratia in terms of a notification dated 14/11/2014 of the Revenue and Disaster Management Department, Government of Assam. And therefore, otherwise also the writ petition suffers from lack of merit. Full stop. As the petitioner is not found to be interested to pursue the writ petition, this court, without going into the merits of the case, is of the view that the writ petition is not interested to pursue the instant writ petition, therefore, which is shown by their repeated absence on 2 dates, and therefore the writ petition is dismissed for non-prosecution.
Item 38.
May I please, Lordship?
Yes.
Lordship, my learned counsel was in court, but due to his sudden ill health, they had to leave, Lordship. Fix a short date if possible.
Wait for necessary order. Mr. J. Learned Counsel has appeared on behalf of
M. Soikia.
M. Soikia, Learned Counsel for the petitioner. In the order dated 19/5/2026 of the Lojima Court, it is reported that the petitioner has not taken any steps for issuance of notice to the respondent number 6. Despite being afforded several opportunities for compliance, an accommodation has been sought by Mr. Pedos to take steps upon the respondent number 6 within a week's time. The prayer is allowed. Raise the case on so and so.
1507, 15 July.
15 July.
Item 41.
Yes.
Item 41, Lordship, we have circulated an adjournment slip, Lordship. As per this note,
Who is entered? You have entered.
No, Your Lordship. Arbor Pujari, his.
What is the case about sale permission?
Lordship.
Heard Mr.
S.M. Munir.
S.A. Munir.
Has been received, Your Lordship.
Yes. Compliance.
No, Your Lordship, Mr. Arbor, Lordship, after 5 minutes, Your Lordship, is on this way.
Item 42.
A. Islam. For the petitioner.
Service complete, Lordship.
Who is for the respondent? Revenue is there.
Yeah.
And Bodoloi, revenue 1. Mr. S.K. Hazarika, 2 and 3. In view of the order dated 12/6/2026 of the Lojima Court, service of notice upon the respondent number 4 is treated to be complete. Post of no counter affidavit has been filed on behalf of any of the respondents. Post of list the case on so and so, let the case be listed on so and so. In the meantime, the respondents shall bring their stand by way of counter affidavits.
interim order passed earlier.
Interim order. The interim order passed earlier shall continue till that. Yes.
Actually, the affidavit is ready.
Well,
Sent for.
I am granting you 4 weeks time.
Item 43.
MU Mondol, Learned Counsel for the petitioner. And
This note says service upon respondent number 4 to 6.
Miss N. Modulo, Revenue 1, HK Azurika 2 and 3.
Instruction is in it.
In view of,
Nutrition.
in the order dated 26/5/2026 of the Zima Court, it is reported that service of notice upon the respondent number 4, 5, and 6 is complete. In view of the matter, service of notice upon the respondent number 4, 5, and 6 is treated to be complete. None has appeared for the respondent number 4, 5, and 6 till date. Post of. No counter affidavit has been filed by the state respondents, by any of the state respondents till date. Let the case be listed on so and so for filing of counter affidavits by the state respondents and for appearance of the respondent number 4, 5, and 6.
2407. Item number 44.
Yes, what happened?
Lordship,
Why?
in the last occasion, Lordship, your honorable court has directed to obtain instruction as to whether the account of the petitioner can be permitted.
No, why it has come for orders, not for making submission on merit.
But as per the
6. We'll see. Then who is for bank? Anybody from bank? Anybody from bank?
Yes, your Lordship.
Yes.
Respondent
You
number
appear for whom?
2 to 5.
2
Postal
to
bank.
5.
Yes, I will file the work out, your Lordship.
Right. Mr. D. Sharma for the petitioner. Mr. B. Chakraborty, Central Government Council for the respondent number 1. And Mr.
G.K. Deca.
G.K. Deca, Learned Council for the respondent number 2, 3, 4, 5, and 7.
No, on 2 to 5, not 7.
2 to
7
5.
is Indian cybercrime.
Then something wrong in the order. Seven you can represent. This is a government of India thing. Okay. Mr. Chakraborty has submitted that notice may be issued to the respondent number 7. Post of. Peruse the office note dated 15/6/2026. Post of. Let the case be placed before the Lord Jima Court to ascertain to report as regards service of notice upon the respondent number 6, comma, and to list the case thereafter. Post of. The Learned Counsel for the petitioner shall take steps for service of notice upon the respondent number 7 by speed post within 2 working days from today. List the case on so and so.
1707. 17 July.
highly obliged.
Much
Respondent bank shall bring their stand by filing its response before 20/07/2026.
Much obliged. We file an affidavit. Much obliged. Item 45.
Yes, you are Mr. N.K. Alom. P.K. Medhi, Central Government Council. 1.
Respondent number
Mr. M. Sharma, Learned Counsel for the
Respondent number 2, Bandhan Bank.
2. Okay. Are present. Heard. Yes. So it is complete. Service is complete.
Complete.
Now you have any instruction?
No, your lordship, only yesterday we come to know that this
Okay.
case is been. And even the copy I have not received.
Mr. Alom.
NK Alom.
Alom, Learned Counsel for the petition shall furnish a copy of the petition along with annexure to Mr. M. Sharma by tomorrow. The bank, respondent number 2 bank is to bring its stand by way of affidavit on or before the next date of listing. List the case on
22nd July, 2207. Item number 46.
E. Deori, petitioner.
We've taken
Petitioners.
Number 7.
As
per office note dated 6.
SK Hazarika 1 and 1 and 5. Miss Bordoloi. 2. BC Musahari or Miss
Ardas.
Ardas. Then sending us a BTC for 3, 4, and 6. And who is to be served? Respondent number 7.
7. We've taken steps, your lordship. As per
In view of office note dated pays the office note dated 15/6/2026. Let the case be placed before a law Jima court for a report as regards service of notice upon the respondent number 7 and thereafter to list the case. Full stop. Yes, respondents. Who is the concerned respondent? BTC. Okay, Miss
Ardas.
Das. How much time?
2 weeks time. After
weeks time.
vacation.
She knows about the vacation. That is why. Ms. Das has sought for and is granted 4 weeks time to file the affidavit on behalf of the respondent BTC authorities without fail. On or before
3rd August, 0308.
without fail.
I'm very grateful.
List the case on list the question date to issue, no?
47.
Your lordship, matter regarding.
As Bormon.
Yes, lordship.
Then
On last
who else?
occasion.
SS Roy, Government by Akhya Hazarika. Please come forward.
On last.
Oh
occasion.
no, you're not Central Government Council. Who is the bank? State Bank.
State Bank.
Any state bank, Mr. Sharma?
This is my salary account since
Wait. If the
Yes.
state bank is not here, how can I?
Yes, lordship.
Pays the office note dated 15/6/2026. Let the case be placed before the Law Jima Court for a report as regards service of notice upon the respondent number 3, 4, 3 and 4. 5? Oh. Something is wrong. Direction was not given for 5. Okay. You take steps. For a report as regards service of notice upon the respondent number 3, 4, and 5. Full stop. On the previous date, notice was not issued.
One is remaining.
One is not very necessary party.
Yes.
The petitioner shall take steps for service of notice. I'm the respondent number 5 by speed post within 2 working days from today. Leaves the case on.
Item 48.
Mr. K. Deka.
The respondent is Your Lordship Bandhan Bank, Your Lordship.
Who else? 3 and 4 or 2? Where was the office note? Mr. Sharma,
Yes, Your Lordship.
are you appearing?
Yes, yes.
Bandhan Bank.
Yes.
Okay.
Copy.
Mr. Sharma, I am Sharma, Learned Counsel has submitted that he has instruction to appear on behalf of the respondent number 2. Full stop. He has on appearance shall apprise the court as regards region. Why it is kept to tell?
Your Lordship, copy not.
Mr. Dekal, Learned Counsel for the petitioner shall furnish a copy of the repetition along with annexure. To Mr. Sharma, by tomorrow, in order to enable him to obtain instruction in the matter as observed in paragraph 6 of the order dated 22/05/2026. So any amount is to be kept in lien, that part.
Yes.
What is the suspected?
Amount.
How much time you need?
Your Lordship,
30 Kata branch, Moirabari,
nearby.
Morigao.
Morrigan.
How much time?
Your Lordship, any date may be given, Your Lordship. Even this before vacation, it may come. Your Lordship.
Okay, raise the case on Wednesday.
2406.
Make an endeavor.
Yes, yes.
Supplementary list. Item number 63.
Rasan here.
This case, Mr. Soduri has filed 2 implement petition method, and accordingly on 15/5, it was both the petitions were allowed, and we filed an amended cost title even method, but it was not accepted because of the fact that on last order 15/5, there was a small mistake method. Instead of respond number 5 method, it was written as respond number 4. My method may take up petition number
15/5?
IA number 2124 method. Method. So, Milord, last but one paragraph, Milord. Order dated 15/5/26. Resultantly, the applicant Sri Gopal Boro.
I can't correct unless something is. This is a judicial order. It has to be not by.
No, Milord, this is order dated 15/5 of the honorable.
Is it not a judicial order?
No, Milord, this order 15 May.
Is it not a judicial order? Passed by a coordinate bench?
Yes.
Yes.
If there is to be some correction, even if by typographical error, that has to be by way of an application. I cannot.
Yes. In fact, that probably my learned friend could come to know only the day before yesterday when it was submitted that there was an
Instead
error.
of what? Gopal Boro should be correct.
Gopal Boro is correct. Number is
number 4 is not correct.
Yes, it should have been 5.
All right, I will file.
Okay, Mr. R. Chakravarti, Learned Counsel for the petition has sought for listing of the case after 2 weeks in order to file appropriate pleading for a typographical for correction of an inadvertent error crept in the order dated 15/5/2026 passed in the IA civil accompanying connected interlocutory application IA civil number 2124/2025.
The similar order will also be applicable in respect of the another IA.
2174.
As well as
2174.
as interlocutory applications in so and so and in I number
2174.
2174/2025. Mr. A.K. Chaudhuri, Learned Counsel for the respondent, private respondent.
Private respondents.
And Mr. S. Bora, Learned Standing Counsel, ZMDA are present. You file the IA, it will be listed.
I'll be filing because
Whoever,
I have to- anyway.
Okay, R. Chakravarti then.
A.K. Chaudhuri.
A.K. Chaudhuri. R. Chakravarti present. At whose instance the IA was filed?
At my instance.
Okay, A.K. Chaudhuri. Learned Counsel for the respondent number?
5.
5.
5 to 11.
5 to 11, that's applicants in I number so and so and so and so. File a pleading, then it will be listed automatically.
Yes.
Published.
Item 41.
And you're gonna see. Oh, yes, what? Mr. Borpuja, you have entered appearance.
Yes, my
Or?
lord. For R1, my lord.
R1.
R1, your lordship will kindly
But,
accommodate me
no-
for some time. I will be filing my affidavit, my lord.
Because, okay. Heard Mr. S.M. Munil, Learning Counsel for the petitioner, Mr. R. Borpuzari has, Learning Counsel has submitted that he has entered appearance on behalf of the respondent number one
One.
and has sought for 4 weeks time
4 weeks time.
to obtain necessary instruction and to file a counter affidavit on behalf of the respondent number one. Full stop. Peruse the office note dated 15/6/2026. Await for the service report in respect of the respondent number 2. Lease the case on science.
And so obliged, my lord.
Yes.
Here's a prayer for me. Sorry, Malov. In the main petition, there was an interim order. That may be.